split, or were they shiny metal things that, like those 9mm shell casings? In any event, the police found nothing, no evidence of a shooting whatsoever, no bullet holes, no blood, no damage to any one of those cars, which would have almost been impossible. No damage to any one of those cars in the parking lot right there. And of course, no shell casings. This bears emphasis. The police found no shell casings whatsoever in 140 minutes worth of combined searching with searchlights. But really, wants you to believe he found it by himself with a cell phone flashlight in 2 to 3 minutes. An hour and a half later. Flies in the face of common sense, flies reason. And what does the prosecution do to try and get around that devastating fact in their case? They suggest that the police didn't know where to look.
Good morning. Good morning. Hi, Hippista. Good to see you. Oh, man. I thought the YSL RICO trial was a giant waste of tax dollars. And let's be honest, it has nothing on the waste that is the A$AP Rocky trial. Ugh. Ugh. All right, guys. I got new glasses. All the Filipinas wore glasses like this, and I thought they were fabulous. So I came home and got myself a pair immediately. I still have my grill. I'm very pleased. If you're in DFW, Studio Smiles is where to go. Okay. Thank you for joining me this morning. Make sure you're in the chat. My daughter actually asked me yesterday. She said, do you like script it, or you just go like balls to the wall? And I was like, yeah, I don't script anything. I said I have an idea of like some of the things I want to show, but I don't script anything. And I told my daughter I love when people get in the chat, because then we can have discussions and I can go off on a tangent. And so Mac Truck already wrote, I am worried. I hope the defense's case was strong enough to convince the jury so he gets to go home to his family. Well, fortunately, the defense doesn't have to have a strong case. In a criminal trial, the government has the entirety of the burden, and their burden of proof is beyond a reasonable doubt. So the defense could say absolutely nothing, and that would be okay. The key is the prosecution's case strong enough? And I don't think so. I don't think so. I am guessing. Good morning, Denver. Sunday, how are you? My understanding is that in about an hour, the jury will come and then begin their deliberations. I am guessing that by 1 o'clock my time, so like 3 hours from now. Oh, thank you. I love them too. But I'm guessing within the next 3 hours, there's going to be a verdict. I think this is a pretty easy case to determine. If you've ever watched, I don't know, CSI, Forensic Files, any television show at all that has to do with crime, you would know, or you would believe, that it is the police's job to collect the evidence. The victim does not usually bring the evidence to the police station. So I think it's an uphill battle for the prosecution, to say the least. So my understanding is that Riri showed up yesterday with the kids in tow, and I think that's genius. Genius. Don't put this loving father behind bars. I mean, honestly, how could you find this man guilty if you watched any of Relly's testimony? Hippie used to think it's going to be a fast verdict too. So I just think it's going to be real quick. They might spend like an hour or two to kind of appease the court and the judge and make it seem like they were thinking. But I just don't see, I just don't think this is going to take long. I think it's pretty cut and dry. All right, so what I want to do as we wait for the jury to come in today is go over the last couple witnesses that were actually interesting. And that was on day 10. Okay. Now, I said this last week. I'm going to say it again. I love this judge. I love him. I love him. I love him. Okay. His interest in judicial efficiency is aligned with my heart. Do you understand? Efficiency and Lauren. So we'll go to day 10. We'll watch parts of day 10. And then we'll watch parts of the closing arguments. And then, as soon as there's new updates, we'll go live with those. Okay? Okay, so. Hi, Enye. Hi, everyone. If you're not in the chat, get in there. Let's talk. The chat is how y'all are the ones who inspire me. You keep me motivated. So tell me your thoughts. I mean, I'm just... Belinda and I... we've just like... This is why we don't live in California. Okay, this is ridiculous. Not only is there an incredibly valid self-defense argument, there's a self-defense of others argument. All right? And in the closing, the defense mentions how the scrapes on the knuckles are ridiculous. Okay, so let's get in. This was Tuesday morning? I can't remember. Anyhow, this judge was like, he's just not having these people, and I just adore him.
Section 1054, and it lists a number of areas that Mr. Levin is going to be testifying about. There was no mention in the summary about him taking possession of the prop gun and what he did with it after. Now, there's a case called People versus Jackson. That site is 15 Cadillac Court, 1197. In this case, the court completely precluded defense witnesses, a defense witness. Because here, I'm going to quote from the case. Here, because the testimony was allegedly exculpatory, the trial court refused to believe defense counsel did not seriously consider calling the witness until moments before he did. Even if withholding the identity of the witness was not willful, lesser sanctions would not have been accurate. Immediate disclosure.
Okay, so if you were with me in YSL, in Georgia, the defense had no obligation to turn over discovery to the prosecution, which makes sense to me because the prosecution has the burden of proof, right? They shouldn't even bring this case unless they think they can prove it beyond a reasonable doubt. So here, this is California, they do things different. It sounds like in California, the defense does have a duty to disclose the witnesses and at least an abbreviated version of what they think the witness will testify to. Hey, Reggie, welcome. Thank you. So right now, the judge, so my understanding is this witness was now going to say, oh, I took the prop gun home, blah, blah, blah. But that wasn't in the summary from the defense. So the judge right now is determining whether or not the defense can even call the witness.
Disclosure or contempt of counsel would have been insufficient because the people would not have had a meaningful opportunity to rebut or impeach the statement. Similarly, a continuance would have been inadequate because the declarant's whereabouts were unknown and thus her unavailability precluded the people from cross-examining her. The people would have been unduly prejudiced by admitting the testimony without an opportunity for cross-examination, and the integrity of the adversary process would have been compromised, as parties with little to lose would be encouraged to not comply with pre-trial discovery rules. The court did not abuse its discretion in precluding the testimony. And this is what the court in Jackson also ruled. Rather than comply with reciprocal discovery rules by giving the people the name of the witness and the proposed testimony, he chose to surprise the people with the statement at trial, admitting such potentially unreliable evidence, untested by cross-examination, would not only have prejudiced the people's case, but would have undermined the discovery process. So the situation we have is not quite like Jackson, but it approaches Jackson. I believe that under Jackson, I would have had the authority to preclude Mr. Levin from giving any testimony about this recently discovered evidence, or this information that was recently turned over to the police about him taking possession of the prop gun and what he did with it. If I did that, however, the defense case would be prejudiced. But then I'm also concerned about prejudice to the people, because this came late in the game.
Okay, so again, I love this judge, not just because he yells "stop it" all the time, but it's a balancing act, and he is doing what he's supposed to do. Analyze, is there prejudice to the defense? Is there prejudice to the prosecution? Like, that is his job, and we're watching him do it. Thank you, Judge, for doing your job. Over in the Florida, in the Melly case, the judge refuses to do his job. Good morning, Tall Glass. I'm glad to see you here. I hope you stick with me through the whole stream. I can't wait to see this verdict.
So this is the way I thought it could be remedied, so that neither side is prejudiced and both sides can fully present their case. Before Mr. Levin takes the stand, I required that he agree to a complete interview by the prosecution, and I understand that happened.
Yes, after initially refusing to speak with us, he spoke to us a few moments ago.
I also required...
See how the prosecutor, after initially refusing to speak with us, the judge does not care. This judge does not care. The added commentary just irks him, and I love that.
That the person who took possession of the gun, the director in New York, that he be interviewed on tape by the people, and if Mr. Levin testifies to anything that is inconsistent with any prior statements he made to this person in New York, that the tape can be played to impeach Mr. Levin's testimony, if there isn't.
Okay, so hi Goddess, good morning. If y'all remember, and if you don't, I have a whole video on impeachment. Impeaching a witness is showing physically where their statement is inconsistent with what they just said in court. So this judge is saying, I ruled that Levin can testify if he talks to the prosecution, and that there needs to be a recorded discussion with the director who took the gun. And then if the director says that Levin said something different, that video clip can be used to impeach Levin.
So that's the way we're going to remedy to ensure both sides are treated fairly, neither side is prejudiced, both sides get to fully present their case.
And I think that's a really good remedy. I think this, I love this judge. It's a good remedy. It gives the prosecution opportunity to interview, it gives them an opportunity to impeach, and it gives the defense still the opportunity to present their case.
Now, I understand, Mr. Lewin, you interviewed Mr. Levin for a period of time, and you said some additional information has come forward that you did not have on Friday, which relates to the witness on the stand now?
Yes, Your Honor, both from, it's going to be important, I don't want to disclose it, but I can tell you that based on what we're being told now, there are going to be questions I'm going to have to ask of the current witness on the stand. With that in mind, I'm asking the court for an additional 30 minutes, and I understand the court is given 90. I'm going to ask for an additional 30 minutes, and I can promise the court I will finish during that time.
All right, is this information that you did not have on Friday while you were cross-examining the witness?
Yes, that is correct.
So when did you discover this additional information?
Well, I discovered it in speaking to the...
Okay, so the prosecutor, who I just think sucks, this guy's not the worst. This guy is, ugh. He had been limited to continue his examination of 12E, I'm assuming because he just started repeating himself over and over. And now he's telling the judge, we just obtained new information and I need to continue to cross-examine 12E.
The individual, just so it's clear, when they turned over the information last night, they still did not identify who the person was. When the court ordered that it be turned over this morning, they didn't immediately turn it over. I found out who the person was sometime around 8:30 this morning, and we were able to call him, and we interviewed that individual.
Did his identity and contact information come from someone on the defense?
Yes, so eventually they supplied it. I sent a very nasty email explaining to them that I wasn't asking for it. The judge ordered it.
Of course he sent a nasty email. He's nasty.
And they better turn it over. And they finally turned it over.
All right.
They interviewed him this morning. We then interviewed Mr. Levin. And there are, as a result of those two interviews, there are some issues that I now know.
All right. Okay. I had said Friday, 90 minutes, and that was in stone, 90 minutes. However, because of the new information, we'll get the additional 30 minutes.
Okay, so he's getting 30 more minutes with 12E.
So it's a total of 2 hours and not 121 minutes, 120 minutes.
Right, although you did say, Ron, you would let my co-counsel have the clock.
Yeah, I don't care who times it, but
You were a little quick on what?
I don't care who times it.
so it's going to be 2 hours from the time he takes to stand.
Yes.
I just want to remind everybody at council table, CCP 177 still applies. I'm not going to tolerate any speaking objections, arguing with the witness, arguing with each other, snide comments made to each other, and arguing with a decision of mine. That still remains in full force and effect.
Okay, so a few days before this, because everyone keeps making speaking objections because Rocky's lawyer is not good at objecting, the judge made an order that if you do a speaking objection, if you argue with a witness, if you're snide to each other, you're going to be fined and sanctioned $1,500 for each occurrence. That's important because later the judge says, I'm documenting the occurrences. Okay, so he means it. These men have been horrible to each other. I mean, I swear the state should have had a lead prosecutor that's a woman, honestly, because it's just been a total cockfight the whole time. It's so annoying to watch. All the posturing, it's like, ugh. Okay, here we go.
All right, let's bring in the jury.
Your Honor, one last thing to put on record. One, regarding the court's last comment, I just want to make sure we have to get into rounds because we cannot respond to the grounds. Court's ordered it, so
The defense is well aware.
Okay.
If there's an objection, the legal basis has to be stated.
The second issue, Your Honor, the court said the court did not want to, quote, cast aspersions to either side. The court has found that this was not inadvertent.
That's right, and nothing more need be said about it. I did not find it was inadvertent. That's why I came up with the remedy I did. I don't want to talk any more about it than I already have. Let's bring in the jury. Oh, and 12.
All right. So, I hope that y'all watched Relly, or watched me last week and saw Relly and his combative nature on the stand, because I'd like to contrast that to 12E and how 12E answers these questions. Okay, 12E is a superb witness. I'm like, damn, 12E, you could be a professional witness. Like, he is great. So, here we go.
First incident, second incident is the one in the parking lot. You understand that now?
Yeah.
So I want to ask you, how did the first incident
Y'all, is this Ills? Is this Ills?
by the parking garage entrance, how did that end? What caused that to end?
By me telling Rocky to go around the corner, and also by Ills, but I guess trying to calm down Rep.
You would agree that that first incident ended only because there were literally people walking by the defendant as he took out that gun, correct?
No.
Do you remember people walking by the defendant as he had the gun out?
I remember seeing people walk up the hill, yes.
This is my question. Do you remember seeing individuals walking directly by the defendant after he removed the gun and had the gun in his hand?
I did not see individuals walking directly next to him.
Okay, let me show you. We're going to put up again People's 15.
Okay, listen to the prosecutor's tone. This is not the appropriate tone or the appropriate time for the tone. Oh, okay. I need somebody help me identify who is who in these videos, okay? I know this is Rocky, this is Relly.
So I want you to watch.
Oh, no, sorry. Okay. Oh. So is that 12E in the middle? Is this Rocky?
You're going to see steps. There's a gun out. Now they're off camera.
Okay.
And you see Sabit.
Okay.
Did you see two sets of footsteps that were walking from the direction to the left of the screen, past where you guys were all standing, toward the right of the screen?
Yes.
And would you agree that if we rewind that, they are literally walking by? You can't see where they are, but you can see their feet. They are walking by literally the spot where the defendant has the gun at the time he has the gun out, correct?
Can I see it again?
Sure.
All right. I need y'all's help with this, okay? This video sucks.
They're off screen now. There's the gun. Gun is put back, and there are those individuals. You would agree they've walked.
Oh, I thought these individuals were part of the shakeup. So, okay, so is the prosecutor saying that these people's feet right here are not part of the fight? I
Walked extremely close, if not directly by where the incident was occurring, correct?
They walk by his, yes.
So you would agree that if Mr. Mayers had decided to use that gun right at that point, that would have been directly in front of those individuals.
Can you rephrase it?
So if he had decided, I want to take that gun out, and I want to use it, I want to shoot it at Relly, that would have been done directly in front of those two people.
Objection, speculation.
I can't answer a hypothetical question, but he did not do it on the screen.
12E made the objection on his own. I can't answer a hypothetical question, but what I see on the screen, no. It just goes downhill from here for the prosecutor.
Listen to my question. You just agreed that they were literally walking by the exact spot where this incident was going on, correct?
Yes.
So what I'm telling you, asking you, would you agree, sir, that if Rocky at that point, Mr. Mayers, had actually used the gun that we saw him remove, it would have been done directly in front of those people?
Objection calls for speculation.
There we go. There we go. There's the proper objection.
I can't agree because you see him going in the opposite direction, and you can see the people walking in another direction from him. You don't see them running. You don't see them trying to like evade anything. You just see them walking.
So I didn't ask you, sir, if in fact those individuals.
What a great point 12E just snuck in there, right? Because if I'm walking down the street and I see a gaggle of men and a gun, first of all, I'm not walking down that street anymore. I'm hauling ass as far away from that scene as I can get because, you know, as a human, it is my instinct to protect my own life, right? So his point is like, you don't see them. So they, yeah, great point.
Ever saw the gun. I asked you, would you agree that if he had decided to use the gun at that point, it would have been right where those people were, correct?
I can't agree.
All right. What after the first incident?
I can't agree. I swear, honestly, 12E, if you're watching this, holler at me at Cadillac Law. I need you to train my witnesses. This man could be a witness trainer. Okay, he is doing so well on this cross-examination.
Incident ended. Would you agree that although Relly was angry, he did not ever respond by pulling any weapon himself, correct?
Correct.
And would you also
Notice he answers honestly. Notice he does not look angry. He looks relaxed. His suit looks a little big for him, but he's not raising his voice. He's just answering the questions.
agree that as you're personally aware, Relly never had any weapon with him that you ever saw during either of these two incidents, correct?
Aside from using his hands, I didn't see anything else.
So I just asked you about a weapon. Did you consider Relly's hands to be a weapon?
Honestly, yes.
Yeah.
Okay.
Okay, I've been watching this show on Cinemax, or it's on the Max app. It's called Warrior. It's based in like 1840s Chinatown, and this guy comes from China to try to save his sister and da-da-da. It is like a total like kung fu show. They're great, like sword and hand fights the whole time. When I tell you more men on this television show have from hands, I'm like, we should go back to that, man. We need to go back to the hands are weapons. Hands are absolutely weapons. Hands, arms, legs. Like, how do you think humans hunted and gathered and existed in the beginning before we invented guns and swords? Hands. So I loved his answer. I love all his answers. 12E has been amazing.
So other than his hands, did he have a weapon? Gun, knife, club, any weapon that you saw?
To be honest, I only seen his hands, and his hands could be considered a weapon.
If you can answer the question I'm asking, it would be helpful. Listen to my question, sir. Did you ever see
The attitude. If you could answer the question I'm asking, it's not a good fit for this witness. It's not a good look for this witness.
any weapon other than his hands in Relly's possession at any point during either of the two incidents?
I seen his hands, yes.
Your Honor, good morning, Mr. Ellis. We understand that you believe that Relly's hands were weapons.
Yes.
What he's asking you, though, is did you see him with a gun at all? Any time that night?
I said no. I said
All right.
what?
Did you see him with a knife?
No.
Did you see him with a club?
No.
Did you see him with any kind of weapon that could be offensive weapon that could be used against someone else?
No.
Thank you, Your Honor.
Did you see the judge's look? This case has been pure comedy, guys.
Anything that you remember happening after the first incident ended. So what happened?
After the first incident happened, after the first incident happened, I just recalled Rocky being around the corner first, because I told him to go. Also, Ills trying to calm Rel down, Rel in the back, kind of angry and like downtown, getting ready to make a move, but I'm telling Rocky, yo, leave. You know, so that's the first thing I seen. First thing I seen was Rocky leave, then Ills speak to Relly, and then Relly start picking up more energy to like get closer to Rocky.
And it's your testimony at this point in time. You have not seen Relly hit anyone, correct?
Not yet.
Okay. And you've also talked about how large and muscular Relly is, correct?
Yes.
You mentioned that Relly is much stronger than you. He's much stronger than Ills. He's much stronger than Mr. Mayor, correct?
Yes.
So would you agree, sir, that the reason that Relly hasn't hit anybody at this point in time is because Relly didn't want to hit anybody at this point in time?
Speculation.
Speculation.
Read the question back, please.
Would you agree, sir, that the reason that Relly hasn't hit anybody at this point in time is because Relly didn't want to hit anybody at this time?
Sustained.
Yeah.
Was there anything
Sustained.
preventing Relly from punching Ills?
At that moment, I feel like his I was on Rakim, so I'm not too sure what was his state of mind. I'm not too sure.
I didn't ask you state of mind. I'm going to ask you again. He's right next to Ills, correct?
Yes.
Is there anything that would have stopped him from physically being able to punch Ills?
He did end up punching Ills.
He did. He punched Hills. Which, by the way, triggers the self-defense of others' defense. Hello?
You just testified that he did not punch Ills.
No, I'm saying he did end up punching Ills. So can you explain it to me so I can understand?
Sure. I'm only talking about this first incident, all right? You were saying, you talked about how Relly was angry.
Yes.
And even though I didn't ask you, you interjected during the last question how Relly was, quote, planning his next move or about to make a move. So my question is, since you said Relly was, quote, about to make a move, you would agree that at that point in time, we're still at the first scene, at the parking structure, there was nothing to stop Relly from punching Ills right at that time, correct?
Correct.
There was nothing to stop Relly from punching you at that time, correct?
I wasn't that close. It was space between us.
Well, did you ever see Relly charge you and try to punch you?
Yes, I did.
So you're telling me that.
This prosecutor, oh my God, I hope he's fired after this. He is far too aggressive, and he's just done a terrible job here, guys.
At that first incident, you are now testifying that Relly tried to punch you.
I'm saying, when we turned the corner, this is still a part of the same incident. I understand you're trying to separate it, but it's still the same incident when he's coming around the corner.
And you're telling me Relly tried to punch you when he went around the corner.
Yes.
And can you tell us
Yes, that's literally what I'm saying.
where in your statement you ever mentioned this fact that you're now testifying to?
Objection, Your Honor, it's not a statement. Good list.
It's a statement that they provided. You want me to show you the statement?
I don't need to see the statement.
Have you ever told the defense
I don't need to see it.
that the defendant, that Relly tried to punch you in this case?
I had to tell them that because you can see it clear on the video. He's coming towards me.
So you're saying he's coming towards you, and you're saying he tried to punch you. Which is it? Did you physically see him with his fist try to punch you?
So, would you like me to explain? I can explain.
No, I want you to answer the question I've asked.
Yes,
or no?
yes,
Yes,
yes.
yeah, I saw it.
One, after he hit Ills, I heard him running towards me, and then that's when I puked, and I run to the side.
Well, you just testified, sir, that Relly never tried to hit Ills at the first scene. That didn't happen until the second scene.
Okay, I'm explaining the whole situation. So, to you, like,
Look at this asshole. It's not a first and second scene. It's one incident. You have a video clip from one place and a video clip from others. So you could say first video clip, second video clip, but it's all one incident. And the fact that the lawyer is trying to bifurcate it just tells you that he's desperate. Hey, Brownie, welcome.
one incident, two incidents, to everybody, it's just one incident.
No, sir. I clarified with you, and you told me you understood. We were talking about two separate incidents. I asked you specifically what happened during the first.
So the first incident.
I'm not done with my question. When I'm done, you'll know.
Judge.
If I'm a juror, I'm wondering, why is this asshole beating up this poor witness? Here's the thing. It's one thing to be a super dick when you have no jury, right? The way this lawyer's acting. I acted that way before when there's no jury. It's just me and a bunch of lawyers, right? So we just like get to it. And you can be rude or whatever, no problem. But in front of a jury? I am my best self. I am a self that doesn't exist outside of the presence of a jury. I am soft and sweet and vulnerable. And if I feel like a witness is not answering my questions, I'll object to non-responsive and ask the judge to step in. I want the judge to be a dick, not me. I want these people to like me. I want these people to rule in my client's favor, okay? I want these people to go my way. You don't, what is it? You don't get bees with lemons or something. I mean, it's just that his behavior is wild to me. And then look at this. 12E is enjoying the shit out of it. 12E, look at that smile, man. What a fantastic witness. Who said it here? The tall glass, that the prosecutors weren't expecting intelligence from these guys. I agree. I feel like this prosecutor just thought he was going to be dealing with like street thugs or something, you know, people who call it Believeland Avenue or whatever. These people are not in a gang. They're in a conglomerate. These are incredibly bright men. These are smart dudes, okay? So they can actually hear the question and answer it. Again, 12E, if you're hearing this, please call me. I need you to train my witnesses, okay? You could be the best witness trainer in the world. Okay, there it is. You catch more bees with honey than vinegar. And this guy is salt and vinegar. This prosecutor is crap.
Objection. I'm done with the argumentative badgering.
Sir, please listen to my question. I'll let you know when the question is over. You were previously asked.
So you're not allowed to yell it, but you're going to be an asshole quietly. Oh, okay, yeah, that's going to go great.
Whether or not Relly hit Ills during the first incident. You said no. Do you recall that testimony?
Yes.
You are now saying that, in fact, Relly did hit Ills during the first incident, correct?
I'm not saying Relly hit Ills during the first incident. No, he did not hit Ills during the first incident.
So I want to be clear. I'll let you know when I'm talking about the second incident.
No problem.
So what I asked you was, is you would agree that had Relly wanted to hit either of the three of you, Ills, yourself, or the defendant, during the first incident, and between the first and the second incident,
Yes.
there was nothing physically from stopping him from doing that.
If we talk about the first incident, right?
Yes.
The first incident where he put his hands on Rocky.
Yes.
Okay, so the first incident, he did put his hands on somebody.
You mean the first incident where he put his hands on Rocky? Yes. So the prosecutor is like, yeah, admitting that Relly put his hands on Rocky. And look at 12E. 12E, if you're single, so am I. Holler at your girl.
Your Honor, can the court, I have a limited time. The witness is repeatedly intentionally not answering my questions.
All right, listen very carefully to the question and just answer the question. Okay, ask the question again.
Isn't it true that during the first incident and between the first and second incident, that there was nothing physically preventing Relly from punching or hitting you or Ills or the defendant? That's a yes or a no question. Do you agree that that is correct?
I don't agree.
I don't agree. I love it. Oh my God, he is fabulous, guys. This is the, I freaking love this witness.
So my question is, can you tell me, you explain how strong Relly is. You explain that he's stronger than you, he's stronger than the defendant, he's stronger than Ills. So my question is, what exactly was preventing him from punching any of the three of you during the first incident or between the first and the second incident?
I don't know what exactly was stopping him, aside from Ills saying, trying to calm him down. Ills was trying to calm him down. And also, we were trying to get from where we were. So maybe because we were moving, that's the only thing that could have stopped him from hitting us, because we were moving away from him.
Well, Relly did not chase after the three of you running and trying to assault any of you, correct?
He followed us.
Do you know the difference between following and chasing somebody?
Well, I feel like there's different ways to follow. You can follow by walking, or you can follow by running.
Was he running after you guys, chasing you at any point in time?
We didn't run, we walked around the corner.
So if you walked around the corner and Relly did not catch up to you, then you agree he was not running after you, trying to catch you, correct?
That's not true, because when we turned the corner, Relly was right next to Ills.
So now your testimony is that in fact Relly was chasing you down, is that correct?
I said Relly was following Ills. He was following.
Okay, guys, I'm going to put a quick pause just as a reminder, we are demonetized, so if you're interested, please donate to the Cash App and come on in. This is my special guest, Tylen. He is a wonderful person, works with me every day. I absolutely adore and appreciate him very much.
If it wasn't for me, this studio would not be here.
That's not true. Here, you want to listen? We're watching 12E. All right, let's get back to 12E.
So when you get to the area where the second incident occurred, I want you to describe exactly what happened when the second incident began. So I want you to actually explain to us, you're walking between the first incident and the second incident, and I want you to now describe how does the second incident start.
And so we're on the same page. Can you explain to me, to yourself, where do you feel as though the second incident started?
Well,
I just love it.
Wow.
He's like, okay, but the lawyer keeps talking about first and second incident, but won't define which is which.
the second incident, you testified on direct, started when you get to the parking lot.
No, I know what I said, but you asked me a question. I just want to be able to answer the question efficiently.
When you get to the parking lot, that is when, in your mind, the second incident started, correct?
To me, as soon as we turn the corner,
Okay, so which corner are you describing when you turn? And I'm not going to make you just read because I know it's complicated. My question is, are you talking about when you turn the corner right where the parking lot is, where the second incident starts? Or are you talking about when you turn the corner leaving the first incident?
so basically, from my recollection, because I can't see the video right now, the second incident starts as we turn the corner.
Turn the corner.
As we make a left. I believe we make a left.
Into
Okay.
the parking lot?
Okay.
Where
Let's hear it.
Dude,
what?
what do you mean you don't know how to turn a corner?
Well, the issue, Tylen, is that this lawyer is taking this one incident and trying to bifurcate it, right? He's trying to say there was one incident in front of a parking garage and then a second incident when they turned the corner.
All at the same time.
And so, but it's all one incident, right? And so 12E is trying to understand, like, why? What is going on here? So this is the best exchange.
the second incident where the shots were fired, or are you talking about when you
Hi,
Yes.
Nene.
Yes, we have company. I'll be making a special appearance every other week.
Stop.
first leave a block and a half away?
And I'll be
So
back because I want to
notice
talk
that we
about it.
left a whole block away. We started walking.
Bye, guys.
We didn't run because this is still a front, and there was no plan or anything to do with it. So why would we run from a front? We're just walking down the block. So we're also giving him time to just, I guess, calm down. So we just walk down the block.
So you're talking about when you turn left, you mean after you've been walking and you get to where the parking lot is, where the shooting happened, correct?
So as soon as we got down the block and go to turn to the corner, we come around the corner a little bit. Rail attacks the hills.
Okay. And can you describe how he attacked Hills?
From my recollection, he started swinging. He started just, throwing punches.
And those punches were landing on Hills, correct?
Yes.
And you ended up seeing an injury to Hills' upper knuckles, correct? You've seen the injury, is that right?
Excuse me?
Okay, first of all, Tall Glass Tylen is single, so FYI. Back to this. The prosecutor just said Relly hit Ills, right? Now the prosecutor just laid the ground for the self-defense of other defense. I don't understand what this man is doing. It's...
Hills or not Hills, I'm sorry. My fault. You've seen the injury to Relly's upper knuckles, correct?
I never seen him in person, so can you show me?
So, let me ask you, were you aware that Relly suffered an injury the night of November 6th to his upper knuckles? Upper finger, excuse me.
From what I heard, but I never seen the injury.
Okay, I'm going to show it to you now.
I would object to this. If he has no personal knowledge of the injury, he's the incorrect witness to even ask questions about an injury too.
Do you see the injury to his knuckles?
have tripped over my own foot and sustained worse injuries than this. This is not an injury. This is you got in a fight and hit a wall. This is an anger problem. If I am the jury, listen, if I'm on the jury and I see this injury, I'm pissed. I'm sorry, I had to sit here for 12 days for what? For some scratches to your knuckles? Unbelievable.
Actually, the tip, the top of the fingers, you see those fingers to the first three?
Yes.
Have you ever seen that before?
I've probably seen it like on the internet, but I never seen it up close. I never seen it.
And did you see it that night?
No.
Your position is you said Ills was getting punched by Relly, correct?
Yes.
And I don't want to get myself in trouble. Was that with a fist or an open hand?
I know it was his hand. I'm not too sure of the positioning of his hand.
You would agree.
Also, if someone punched me right now in the braces, they would sustain a similar injury. My teeth would hurt like a mofo too, but if you, I don't know if Ills wears a grill. I have no idea. I don't know anything about Ills, but if you hit someone the right way, you could scrape your knuckles.
And you said before, in your direct evidence, your direct testimony and cross-examination, on Friday you said that Relly punched Ills repeatedly with a fist. Do you recall that?
Yes.
So you're now talking about that's the incident you're referring to where Ills was punched by Relly, correct?
Yes.
And that was with a fist, correct?
Yeah, the fist is on your hand, so I believe so.
Multiple times, correct?
I believe so, yes.
And you explained that Relly is extremely strong, correct?
Yes.
Asked and
he
answered.
showed you the pictures of Ills from the next night, and you agreed you couldn't see any visible injuries, correct?
I never said that Ill's face was broken. I never said he had a black and blue on his eyes. I said
Motion
he had...
strike is non-responsive. Sustain. Listen to my question. You testified on Friday that you agreed that Ills did not have any visible injuries, correct?
Oh, can you rephrase that? And do you mean by the video that you showed the next day? You didn't say the video of the event because we can't.
Well, Armin, are you saying you remember him having visible injuries?
I'm asking you, can you rephrase it because you're just saying you're saying from the video or what event?
Well, let's take it one at a time. You testified on Friday that the visible injury, you said that his lip was bleeding.
His lip was bleeding, yes.
And you agreed that in the video that you saw, you couldn't see his lip bleeding.
Which video? That's what it says.
Well, which video? I showed you a video
Would you like to show me again?
on Friday.
Talking about the video that's taken following day?
Yes, the video taken the following day where he has the flag on. You said, we had it up there.
Yes.
You could not see any visible injuries to his face, correct?
Also,
Is that correct?
Yes or no?
yes.
So my question to you is, if Relly is punching him multiple times with his fist, do you know why there was no visible injury?
I have no idea.
Okay. I want to now show you. You said
I would have objected that as speculation, but
that. Let me ask it this way. So it's your position that the second incident started because Relly attacked Ills. Is that correct?
Yes.
And it's your position that that incident started and that it was the defendant pulling out what you said is a prop gun in response to that. Is that correct?
Can you rephrase that?
You're saying that the defendant pulled the prop gun out, what you said is a prop gun, in response to Relly punching Ills.
From the first situation or the second video? Because I'm trying to be sure.
In the second incident,
Yes.
you said the second incident started when all of a sudden Relly starts attacking Ills, punching him.
Yes.
Is that correct?
Yes.
And you've also, I want to be clear, you said that on direct examination that that is the reason that you saw that the defendant pulled out the gun because he was trying to protect Ills who was under attack. Is that correct?
In the second situation?
Yes.
Can you show me the video so we could all see it together and I can explain to you?
Well, we're going to watch the video,
Yes.
but before that, I'm asking you, that is what you have said, correct?
Yes.
All right, now we're going to watch the video. I want you to
Okay.
pay close attention as we watch this video. This is people 17. I want you to pay close attention as to whether or not there is contact between Relly and Ills before the defendant pulls out his gun.
All right, help me with this video, you guys.
You're watching on the top left.
Okay, who's that?
Stop.
Okay. Who is in the red? Who's the one who came in the street? Who is this and who is this? Does anyone know? I'm gonna give you a second to catch up and help me, because this is like the worst video I've ever seen. Like, this video tells me nothing. Yeah, tall Joss. The prosecutor is foul and condescending, and I don't think it's gonna fly with an Los Angeles jury, but who knows? All right, so who's in red? Who's this guy? Who's this guy? And who's this guy? Are they all guys? I don't know who Ills is. I'm not like a big hip hop folder. Another CG, FYI, there would be people dare punch me. One time this woman tried to attack me in the courthouse. She started yelling and I was like, you want to go? Hit me. That's my favorite thing, because if they hit me first, then it's self-defense, right? So I'm like, come on, hit me. The security guards come running and grab her. No, people do want to punch me. I can be quite punchable at times. Okay, so help me with this terrible video footage, guys.
You would agree that at this moment right here, that the defendant has removed the gun and is walking towards where Relly and Ills are, correct?
No.
I want you to tell me, use the pointer. I want you to tell me, identify each person on the screen.
Thank you, Jesus.
Can you rewind it?
Sure.
Right here.
Yeah, we'll rewind it. Who's in the red?
I'm in the red.
You're the easiest one to identify.
Okay, 12 is in red. Okay.
So stop it.
Stop it.
Okay.
That's Rakim.
Okay.
That's myself. I believe over here is Ills. I can't tell you.
Okay. Do you agree that at this point in time, there is no contact, and there has not been any contact at this second incident between Relly and Ills?
Okay, so
Well, yes.
12
Okay.
is
Keep
that
playing it.
Relly Ills.
Stop.
Rocky. Oh, there.
Okay. Watch it again. And I'm going to ask you, when we get there, would you agree that the defendant turns around and pulls out his gun? Stop. Gun is coming out now, and I want you to point to where the defendant is and where Ills is.
Well, I see the defendant, but I don't see him pulling out the gun. I don't see him.
Exactly.
Point to where the defendant is, where Ills is, and where Relly is.
So this would be the defendant.
Yep.
This would be myself.
Yeah.
Over here would be Ills.
Yep.
And I believe this would be Red.
Would you agree that
Oh.
up to this point, Relly, at the second incident, has not made any physical contact with Ills?
He plays again.
Listen to my question. Up until this point, and I'll keep playing, do you agree that there has been no physical contact that Relly has made with Ills?
Right here, there's
Yeah.
no physical contact.
And no physical contact right before, correct?
Right before we turned. Right before he had no contact. Right
Okay, that's at 56 seconds.
It's on the file label combines or is video, Your Honor.
Excuse me?
No, we're just clarifying for the record, sir. So you would agree, this is the beginning of the second incident, correct?
I guess.
I would say this is the second incident, yes.
Is it the beginning of the second incident?
No, because I would say the beginning of the second incident is when Relly puts his hands on Ills. So that's when it becomes an incident. Because before then, we were leaving.
So the second incident hasn't started yet, according to you, correct? There's been no hands,
There's
is that right?
no hands from it. Nothing going on from anybody right
Yeah,
now.
so I just want to be clear. So in your position, where we are right now, at 56 seconds, the incident has not started yet, correct? Is that correct?
Correct.
Okay,
Okay.
watch. Stop.
Okay. Relly goes after Ills hard.
You agree that the defendant advances towards where Relly and Ills are before Relly makes any attempt to make contact with Ills, is that correct?
No.
No.
That's not correct.
Would
No.
you agree that before there's any contact between Relly and Ills, the defendant has already taken out his gun?
That's not correct.
Okay?
Okay.
Please play it, rewind it, and we'll play it going forward. Okay?
Okay, it looks like Relly starts to run for Ills, and then Rocky comes back. Who knows if he pulled a gun?
Keep watching, sir.
Okay. Rocky had already turned around. Yeah. Rocky doesn't move until Relly runs to get ills.
Want to stop? Where were you when the second incident started?
Over here.
Well,
Over here.
So when I said it began,
Yeah.
when Relly attacked Hills, I was right there. I was right next to him.
What did you do?
I ran.
As soon as the defendant, you saw him take out his gun. What did you do?
Oh, the gun.
Can you rephrase that?
When the defendant took out his gun, you ran towards that wall for safety, correct?
No, I ran towards the wall. I mean, if you could play it, you could see Rel coming towards me. That's when I moved.
Play again. So your position is you were going. I thought Relly is attacking Ills. Is Relly attacking Ills or is he going after you?
So Relly hit Hills, he got Hills out the way, and then he tried to hit me. And I stated before, I'm not fighting Rel because my ego hurt him.
We're gonna
So
play.
I juked and moved.
We're gonna play, and I want you to tell me. I want you to yell stop when you see the point where Relly is trying to hit you.
Okay. Okay, good. Let's do that. Relly goes for ills.
Stop.
Now, yeah, there. Right there.
This is where you're saying Relly's trying to hit you.
Yep. And you see
Yeah.
me moving.
I see that.
You agree that by this time the defendant has the gun out, correct?
The warning shot came.
Listen to my question. By this point in time, the defendant has the gun out already.
The
correct?
prop is out after Hills is attacked. Not before, after.
Listen to my question. It's pretty simple. I'm not asking you about when Ills was attacked. I'm saying at this point in the video, before you start running towards the wall, he has the gun out, correct? That's a yes or a no.
I don't recall. I recall the prop being out after Relly attacked, after Relly moved, never before. Not before I ran.
Watch it again, please. You said you don't recall, and then you all of a sudden recall. So watch
I'm
it.
just recalling about it.
Watch it again.
The fucking commentary, dude.
That's the statement by Mr. Edwards. Stop. In fact, sir, you don't run until the defendant fires the first shot, correct?
I don't run until after Relly tries to hit.
Listen to my question. Did you just see, sir, listen, do you see the defendant firing a shot in what we just saw? We'll play it again for you.
Can you play it again?
Sure.
Is
Stop.
That's the first shot.
And you start running right after that shot, correct?
Relly is already running towards me, so.
Listen, vote for strike, John. I'm not asking what Relly did. I'm asking you, this is a yes or no question.
I did not run from the shots.
Listen to my question. I'm not asking what you ran from. Listen. Isn't it true that the time you do not run until after that first shot is fired? Yes or no?
Well, yes.
Okay.
okay. What does that
And
mean?
it's your
Nothing.
position, sir, that you knew it was a prop gun when it came out,
Yes.
correct? And it's your position that Relly knew it was a prop gun when it came out, correct?
Yes.
Wouldn't you agree, Mr. Phillips, that what's happening in that video is not Relly attacking Ills, it's him trying to use Ills as a shield so he doesn't get shot?
No.
Let's run it, please.
No, he does not agree.
Stop. You agree at this point in time at, I can't see, at 55 seconds, Relly still has not hit Ills yet, correct?
Correct.
Okay. And you would agree that right at this point in time, this is when the gun is going to come out, and that the defendant is going to advance towards where Relly and Ills are. Is
I
that
don't
correct? You don't agree with that?
I don't agree.
Watch the video, please. Stop. He is about to fire the shot. Do you agree?
You say he's about to?
Yes. Right
Oh,
now.
okay, so can you play it one more time?
I'm going to play through, but do you agree he's about to fire the shot?
No. Can I see it?
Yeah,
So I
okay.
can explain it to you?
You agree that you have not started moving yet at that point in time, correct? You're not running yet, right? We'll play again. Go ahead. That's okay.
What does this even prove? Why are they spending so much time on this completely moot point?
And now he's about to fire. Boom. Shot happens and you run after, correct?
I run because if you
That is not what I asked you. Motion strike is not responsive.
Stop. The
the answer is non-responsive. Sir, listen, he's asking you a question.
Okay,
Wait, hold on. He's asking you a question that calls for a yes or a no.
I'm not asking you why you ran. I'm asking you, isn't it true that you do not run until after the defendant fired the shot?
that's not true.
That is not true. So, play it one more time, and I want you to tell me when the shot is fired. You tell me when you see that first shot fired, please.
Yes.
Okay, you tell me, you say, stop when the first shot is fired.
Stop.
Okay. Do you agree, sir, you are just about to start running, but you have not started running yet? Agreed?
After the first shot,
Yes.
I'm not running. You see me still right there.
When the first shot's fired, you playing?
The thing is, that's not a shot.
So what I asked you before was, isn't it true that the first shot was fired before there was ever any contact between Relly and Hills? You said no, but you would agree when you watch this, the first shot is fired before your allegation that Relly was attacking Hills, correct?
That is not true. In the
Okay.
video, you can see.
Most strike, everything after that is not true. Isn't it true, sir, that the reason that you ran after the first shot was because you knew it was not a prop gun and you were worried that you might get shot in the crossfire?
No.
No. He has already explained why he ran 8 times. And Patty, how do you disprove something that you yourself admitted? The prosecutor just said Relly hit him, then the gun came out. So he's not disproving shit.
I want you to keep watching the video, and I want you to tell me when you see the second shot being fired. Okay. Let me just stop for a second. Would you agree that between shots, that Relly is grabbing Hills and trying to use him as a shield?
No. Really? The whole time?
Most strike,
The answer no?
No.
All right, the answer's no.
Would you agree that after the first shot was fired, that the defendant is maneuvering his gun in what appears to be an attempt to find a line of fire toward Relly?
No.
All right, let's play it, please. Stop. Is this what we've just seen? Is this where you are saying that Relly was punching Hills?
Yes.
And is this also where you are saying that, having watching this, you do not believe that Relly was attempting to use Hills as a shield?
I do not believe that.
And let me ask them, did you see during the second shot, did you see between the first and second shot, the defendant repositioning himself and running around himself?
Can you rephrase that?
Between the first and second shots, did you see the defendant repositioning himself and the gun?
No.
From my recollection, I've never seen him reposition the gun. I seen him have his hand. I believe.
Most strike, everything else is not responsive. Let's play that again, please. I want you to watch. Defendant literally running around with his gun, attempting to get a line of sight on Relly.
No.
Let me ask you something. You testified that everybody, including Relly, knew it was a prop gun, right?
Yes.
If it's a prop gun, and Rocky knows that everyone knows it's a prop gun, can you tell me, are you aware of why he would have a need to be repositioning himself between shots? Do you know?
No.
Can't speculate.
Would you agree that if it's a prop gun, and that Relly knows it's a prop gun, that it's going to have no effect on stopping Relly from doing anything because he already knows it's prop gun?
Correct, because it didn't stop me.
So, you know, if
Yeah, you're right. It didn't stop him. But he's about to get into a really good point.
you're saying it didn't stop him, this is my question. Your testimony is that the entire time, Relly knows this is a prop gun.
Yes.
You're telling me that when it's pulled on him at the first scene, he basically says, put that fake gun away, correct?
Yes.
You're telling me that the second scene, when the gun is taken out and fired, Relly knows it is a prop gun, correct?
Yes.
You're telling me that when Relly is running around, that he still knows it's prop gun, correct?
He wasn't running around. He's hitting Hills. So he's not running nowhere.
Okay. But that entire time, you're saying Relly knows it's property.
Yes.
Can you tell me, are you aware, sir, of how that prop gun, if Relly knows it's a prop gun, how that in any way is going to stop him from allegedly attacking Hills? Do you know?
Well, just the sound. That's all I can say is the sound.
So you're telling me that even though Relly knows it's not real, that he's going to stop attacking Hills because of the sound from a fake gun that he knows is fake. Is that your testimony?
It was the sound from the prop, also the sound from the car alarms. It was drawing a lot of attention to the situation. So, as you can see, Relly didn't run. He got a couple more hits on Hills.
Moses, okay.
Perfect answer. It's a prop gun, and he knows that, so he's not afraid of getting killed. But the sound of a gun going off is going to make car alarms. It's going to draw a lot of attention. And Relly knows that. So, hi, Flesh of the Gods. Welcome.
Fine. Can you tell me, how does this incident end?
How does this incident end?
How does it end?
Okay. Well, after the incident, as you can see, there's a lot of attention being drawn to us. The car alarms are going off. I push Rocky, yo, bro, let's go. We gotta, because our voice before, yo, we should have been left, you know? So now we're leaving, we're going in the opposite direction.
Let me stop you. You would agree, Mr. Phillips, that this incident ended because you literally pushed Rocky away, and that his initial response was to push back at you as if he wanted to go back and do some more. Would you agree?
No.
Let's watch the video, please.
All right, let's watch it.
Stop. Would you agree, sir? You are literally pushing Rocky away, who is trying to advance towards back what is going on.
No.
So actually,
Motion to strike is non-responsive. That is a yes or a no. Isn't it true that what you just watched, you are literally pushing Rocky away from going back towards where Relly and Hills were?
Yes.
Correct? So, you would agree that as this incident ends, none of you stop to pick up any casings, correct?
rephrase that?
When this incident ends, none of the three of you, Hills, the defendant, yourself, stop to pick up any casings that are at the scene, right?
No.
Is that correct?
No, I left the scene.
Right. None of you go. Do any of you pick up any extended
We
casings?
all left the scene, sir.
Did you pick up any casings?
No.
Did anybody at the scene pick up extended casings?
No.
In fact, Relly didn't pick up anything either, correct?
I have no idea where Relly did.
I thought you said you were watching him the whole time.
Oh, I'm saying you said that he picked something up.
You told us, continue to watch the video, I want you to watch it, and you previously testified that you were watching Relly the whole time. Defendant is running away in this, right?
Yes, he got it.
He's gone.
Yes.
You would agree, sir, that at no point in time did the rest, any of the three of you that were left, pick up anything off the ground, correct?
I didn't pick anything up.
And did you see Hills pick anything up?
It was then he picked the cell up off the floor.
That's not
He picked himself up. I fucking love that answer. I love this answer. I love this witness. 12E, you are amazing. Okay.
Did Hills pick up anything off the ground?
I don't think so.
Did Relly pick up anything off the ground?
Rel was, if you can see the video,
Motion to strike is non-responsive. Did you see Relly pick up anything?
I didn't see Rel pick up anything.
So, it's your position that the first time that you ever saw the injuries to Relly's hand was when?
I'm not too sure the specific date, but it was only on Rakim.
Okay. You ever hit anybody? You ever been in a fight yourself in your life?
Yes.
When you hit him, do you hit him with your knuckles or do you hit him with the injury that he has to his hands?
Well,
What?
I'm not too sure how everybody else throws their punches. Some people only know how to throw a punch, so I can't tell you how somebody else throws a punch.
Well, you basically said that Relly is a very strong guy. You worked out with him. Do you think, based on your experience, knowing Relly for 20-something years, do you think Relly knows how to throw a punch?
No.
Oh, you don't think Relly does?
No.
Okay. So it's your position that the injuries on the fingers were from Relly punching Hills?
I believe so. I feel as though you could see him fighting Hills, and I think he hit the floor. Cause
Motion to strike, everything is after, yes?
Yes, I believe so.
Yes or no question, he had it. You can bring it. But because you understood that he had just shot at somebody with a firearm, and you were concerned that he was going to be in a bucket load of trouble.
No.
And it's your position that at that time, at that date, you knew that there was no way that the defendant could have done any damage to anybody because that was a fake gun.
It was a prop, yes.
And it's your position that Relly also knew that there was no way that the injuries that he had could have been from a gun because the prop gun that the defendant shot him with was phony, correct? Wasn't a real gun.
Can you rephrase that?
So you would agree that Relly also was aware that night that there's no way the injuries on his hand could have been caused by getting shot by the defendant because it was prop gun, wasn't it?
I believe that, yes.
When did you first become aware that Relly was asking Mr. Mayers and his management team for money as a result of the incident?
Probably 2022.
Now you would agree that as soon as you would have heard this, you would have known that that request was bogus because it wasn't a real gun, right?
Can you rephrase that?
As soon as you would have heard
All right, this line of questioning gets stupid. It is so dumb. Just wait.
that Relly was trying to get money for allegedly being shot at, you would have known that that was a bogus allegation, an untrue allegation, because it was a prop gun and the defendant could have never shot him, right?
Of course, yes.
So, after you found that out, tell me when you went to the police to tell them what you knew.
I didn't go to the police.
Now, you discovered at a later point in time that not only had Relly gone to the police, but that the defendant had been charged in this case, correct?
Yes.
And as soon as you knew that, as soon as you heard it, you knew that those charges were unfair and never happened, correct?
Correct.
Did you go to the police then?
No.
Did you call the prosecutor?
I didn't even know who the prosecutor was, so no.
So you were unable to figure out who to contact? Is that why you didn't go forward?
That's why these questions are so stupid. First of all, he's a black man in America, so why would he interact with the police at all, ever? Secondly, how the hell is he going to know who the prosecutor is? Like, thirdly, how is this any of his business? Like, people don't just, like, show up, oh, I have contrafuting evidence. Like,
For one, I just didn't know. You know, I didn't. Nobody said the prosecutor wanted to speak to me. Nobody said LAPD wanted to speak to me.
Listen to my question. I'm not saying whether they wanted to speak with you. This is your brother, who you're saying is being charged unfairly for a crime he didn't commit. And you have the evidence to prove it didn't happen.
Yes.
My question is, why didn't you come forward to tell the police and prosecutor what you knew?
Well, I don't have a particular reason, but they charged him. I guess it was going to trial. I believe I can tell my truth here. I didn't have to tell the LAPD or anybody else.
Wait, you
perfect answer. Perfect answer. I could tell my truth here. Perfect answer. 12E, call me, dude. Call me.
didn't have a particular reason. Wouldn't a particular reason be that your brother is facing serious charges and you are able to tell the authorities it's not true?
I've never been in a situation where you could just go to, I guess, the law and tell them this will happen and a person is innocent.
So you couldn't figure out on your own, Mr. Phillips, that you could have picked up the phone, called Rocky's lawyers, called Rocky himself, called the police, called the prosecutor, say, hey, listen, this is not true. You couldn't figure that out on your own. Is that your testimony?
I've never seen that opportunity available.
At some point, you became aware that Relly had gone to the police. My question is, when did you learn that he'd gone to the police?
To be honest, like I said, it had to be 2022. I'm not too sure.
So you're saying you did not know that Relly had gone to the police until sometime in 2022?
Yes.
Asked and answered. He already told us that.
Now, you knew for sure by April 2022 because it was being published on different websites that Relly was a snitch and a rat, correct?
No.
Oh, you know about that. What number? 22?
This is great, guys. This is great.
Who's out on the left side of the screen?
Hey, is that right?
Who's on the right side?
Barney.
Barney's another brother of yours, right?
Yes.
This is dated April 20th, 2022. You know what No Jumper is, correct?
I'm aware of what the platform is, but I'm not a supporter of No Jumper.
Well, so I want to ask you something. When's the first time that you saw this post that says, at ASAP, Barty says that ASAP Relly snitched on ASAP Rocky causing his arrest earlier this morning. When's the first time that you ended up hearing that, seeing that?
Well, this is my first time seeing this post.
I was today years old when I saw it. Like, come on, this prosecutor is grasping.
You've never seen that post before today?
I'm not, I have my own business. I'm not a part of the jumper.
So, I'm not asking you a part of the jumper.
I'm not a part of no jumper.
When did you first learn that Relly was being labeled a snitch and a rat by other ASAP members and by the rap community?
But they're checking other ASAP members and the rap community.
Also, speculation.
Check the characterization of Stacey Evans
That's,
on record.
no, that's, let's keep the objection again. I'm just responding to that with giving.
Right. Ms. Stacey,
Objection, Stacey.
all right, read that.
Snitch and a rat by other ASAP members and by the rap community.
Also,
I'm not misstating the overall on that ground.
Can you rephrase it?
can you read that, please?
When did you first learn that Relly was being labeled?
Okay, Tall Glass says the seal is up today, so let's head over there. Okay. Now, again, it's the prosecution's job to prove beyond a reasonable doubt. Before 12E came on, the prosecution, they stipulated that it was a prop gun and that the bullet casings they had did not come from that gun. So they already stipulated their trial away. I don't know why any further action was taken at all after that point. I don't know if the defense asked for a directed verdict. I don't know if a directed verdict is available in California. But while we wait here, a directed verdict is basically when the prosecution or the plaintiff rests their case, you ask for a directed verdict, you say, Judge, they have not proved their case by a reasonable doubt or whatever the thing, and you explain what the judge has seen. I have won on directed verdict one time. It was the most amazing moment of my life. It's probably the only time ever, because usually the judges want to allow both sides to present. But sometimes the first side just doesn't even cut it. They just don't have the evidence, and you can disprove on cross-examination. And you can show there's not enough evidence to meet the elements of the crime or, whatever they're discussing. So, this case is just, LA burnt down totally. And of course, after fire comes mudslide. Everyone knows that. Like, the fire burns all the trees, so there's no roots to hold dirt in place. Now you got mudslides. I just read this morning that they're already experiencing mudslides. So if I live in this town where all these people have lost their home, these fires have taken everything, and now there's mudslides, I'm pissed that you had me come to court about this. I am mad. You spent an entire day with a ballistics expert who showed no ballistics related to the crime. You have several witnesses who are educated, put together. They answered the questions clearly. They confirm that either Relly, the victim, tried to publicize and tried to use this as a money-making avenue, or they actually describe the entire story and they confirm that the gun comes out after Relly, the alleged victim, attacks someone. If I'm a juror, I am going to spit on the prosecution. I'm going to be so mad. All this money and time we wasted could have gone to rebuilding homes, could have gone to landslide prevention, could have gone to, I don't know, anything at all. Feeding the homeless. There's a homeless crisis in LA. I mean, there's a homeless crisis across California. It just doesn't make sense. It doesn't make sense. I know the juror number one is a woman because I heard her and the judge talking one day. I just I just don't care who you are. Even a baby boomer, I think, would be like, what is this fucking bullshit waste of time that we're sitting through? Just absolute waste of time. All right, so they're not on yet. Let's keep entertaining ourselves here while we wait for them to come on.
Interact by other ASAP members and non-ASAP communities.
I already talked about it.
So you're telling me that these other ASAP members who you referred to as you are all brothers, correct?
Yes.
ASAP Bari is a brother, correct?
And to be honest,
Yes or no?
I haven't seen Barbie. I haven't seen him.
I have a question. When I'm asking you a question, instead of looking at me, you look over at the jury. Is there a reason why you're not looking at me when I'm asking questions and why you're looking directly at the jury?
I'm looking at everybody. I'm giving eye contact with everybody.
Has anybody told you that when you answer questions, you want to turn and look at the jury? You've been directed to do that?
No, but I have answered
Most
questions.
right, everything else is non-responsive.
Everything after no is
So, this is my question. ASAP Bari, you referred to him as a brother. I'm not on my question. You previously referred to him as a brother. Now you are saying, not only did you not hear anything about these rat allegations involving Relly from Bari, but you never heard about it from any other ASAP. Is that correct?
No,
Is that correct?
no.
It is not correct.
I haven't heard it from anybody else in ASAP. And this is my first time seeing this. Like I said, I do not follow no jumper.
He's great.
What happened? Have you ever asked Rocky what happened with the gun?
No.
Would, if that prop gun were here, and it was believed that that's what was used, you would agree that would be very helpful evidence. So it's fine.
Speculation.
Speculation.
Staying on speculation ground.
Would you agree that since the defendant's charge with firing a real firearm, that if you knew where the actual prop gun was, that would be likely helpful to the defendant?
Understand the question,
Say really.
Where's the prop gun?
I don't know.
Have you ever asked?
No.
So it's your testimony that this incident happened, and the last time you saw the prop gun was when the defendant fired it and put it back in his waistband?
Yes.
Can you rephrase that part?
So, the last time you saw the prop gun was after the defendant fired it at that scene, and you guys left. It was in his waistband, correct?
Yes.
Isn't it true, sir, that after that incident, you, or the defendant with your knowledge, you guys got rid of that gun?
No.
It's not true?
That's not true. I have no idea. Because when I left, I went back to my hotel.
Let me ask you, I want you to assume for a moment that instead of being a prop gun, that it was a real 9mm handgun. I want you to assume that. Are you following me?
You want me to answer?
No, I want to make sure you're following me. I'm having you assume it was a real gun.
I can't make assumptions.
No, you can't. This is called hypothetical. I can have the judge explain to you. I want you to assume, for my question, that it was not a prop gun, that it was a real 9mm firearm.
Pretend it was a real gun.
If it was a real gun, would you agree the defendant would have a motive to get rid of it?
Still speculative.
Would you agree, sir, that being like a brother to the defendant, that you yourself would have a motive to get rid of that gun?
No.
No.
So you're telling me that if it was a real firearm that was used in this incident, that you in no way can see where you would have a motive to get rid of the gun?
No.
No.
Okay. As far as you know, where's that gun today?
Asked and answered.
Where's the problem?
So, the defendant is like your brother, and you speak to him all the time, either directly, in person, by text, etc. Is that right?
I speak to him in person. When I see him, he's very busy, so it's not that often.
Well, have you ever asked him what happened to the gun?
No.
Does that seem like a question that might be important?
No.
No, it isn't. It isn't. It's not something you would ever ask anyone. Like, no. You move on with your life. And 12E obviously has a life, right? So it's this line of questioning is bizarre to me.
Let me continue. Do you still speak English?
Yes.
Okay, here we go.
All right, we're back on the record. All jurors, counsel, jurors, counsel, and parties are present. Mr. Tacopina, the floor is yours.
Thank you very much. Good morning, ladies and gentlemen. So here we go.
Okay, so he's finishing his closing. So let's get to it today.
Where I left off, which was talking about the picture of the extended magazine that we showed you, which described as clear or transparent, whatever it was not black, that extended thing, that Lou and both photos had described. So in the end, the prosecution on this issue, all issues really want to believe really beyond a reasonable doubt, and look, you've all been here for his testimony. I would submit to you that's perhaps the most unbelievable witness in the history of American jurisprudence. You guys have a front row seat to a perjury machine. Again, they could have corroborated a lot of his testimony if he were truthful. Lydia Parker. I mean, they sat in their hands for years. They could have tested to see if Relly's shell casings came from that magazine, the women's magazine. They didn't connect Rocky to Relly's shell casings with fingerprints DNA. And as a quick aside, if you accept their theory, I think I heard this on the opening summation, is that maybe Rocky forgot about the magazine. Why wouldn't he, if truly he had a gun and he was trying to get rid of the evidence of the shooting from November 6th, why wouldn't he have gotten rid of the magazine also? Why keep it for 5 months in plain sight? I mean, that's where it was, right? It's not like it was hidden somewhere in the house. They had to find it. It was in a box in his bedroom with all the other ammunition for the legally registered guns in plain view. They didn't show you, by the way, that the shell casings that Relly claims he recovered at the scene don't match the SIG shell casings found in Rocky's house that belonged to Miss Levin. We had to show you that. We showed you that. They produced, as we talked about, no GPS data to prove where Relly really got his shell casings from. There's another one. This would have been easy to do. Relly claims first he said he wasn't in Los Angeles weeks before. I'm certainly not a shooting range. We won't go through that again. But he claims he left Los Angeles after being at the shooting range for those 9mm shell casings, and then he came back to Los Angeles 2 weeks later. They failed to prove that. I mean, you just had his word, right? That would have been easy enough to prove. I mean, how about an airplane ticket or anything else that he ever left Los Angeles and flew back, ever? After having 9mm shell casings flying to his face at a shooting range just weeks before. He took photos of his shell casings. I mean, that would have been an easy one to prove. Just bring his travel itinerary or an airplane ticket from Delta or wherever. He said he flew commercial. How about on his phone? Anything that would show he actually left Los Angeles. Nothing. Nothing on the record. No evidence that he actually left Los Angeles after being at that shooting range on October 19th. So where did he get his shell casings from? At 11:45 p.m. that night, an hour and a half after the incident. Law enforcement didn't give us the means to answer that question. They never got Relly's GPS data. They could have given a definitive answer to you. They didn't, and that's not on him. That is not on him, because they didn't give you the evidence you could have been comfortable with to rely on, as opposed to just taking Relly's word, which is not a word that you would take for anything of importance in anyone's life. Whether he had him at some apartment in Los Angeles or at some friend's car or some place, who knows? We'll never know. We could have known, but we don't, and we never will. And because the prosecution gave you no one in this courtroom the ability to track where Relly went in the hour and a half after the incident. Only Ill's GPS data did they get. It shows you they could get it, they just didn't get his. They just want us to take his word on that, word of the pathological liar. Look at all the things they failed to corroborate that they could have. To corroborate Efron's account, the DA could have done any of the following. And would have given you a sense of comfort, the sense that, hey, you know what? He did tell the truth about this anyway. They could have called Efron's girlfriend, Lydia Parker, who was allegedly with Efron when he claims he retrieved shell casings. They could have collected GPS data from that night, from Efron's phone, to prove he returned to the scene. Again, they did leave it for Ill's phone, but chose not for Efron. could have looked at the metadata on the photographs that Efron took of these shell casings, which would have shown exactly where he was when he took those photos. These are things they could have done to corroborate him. Go ahead. They could have produced a plane ticket or receipt to show that Efron actually left Los Angeles. After he went to a shooting range 2 weeks before the incident, they didn't do that. They could have called this Cashapp to corroborate the conversation that he allegedly had, that allegedly happened on November 5th, the day before the incident, with Barry and Rakim, which really claims Rakim's bad mouthing. No phone records of that, nothing. And then, of course, they could have tested Efron's casings to see if they came from the magazine found at Rakim's house prior to the trial. They could have tested Rakim's DNA against those casings or the magazine. And they did not. Those are just some of the things. I mean, those are deficiencies in the evidence. And they create reasonable doubts. They're reasonable doubts.
They didn't even collect their own evidence, FYI.
And especially when you consider what Relly did with the photos of those shell casings. He didn't go running to the police saying, hey, help, I was a victim of a crime. He tried to extort money out of Rakim by going to Rocky and his manager first. And I want to remind you that there are 2 hurdles the prosecution has to overcome to get a conviction in this case. First, proving that Rocky did not carry the property. And then, of course, the service. If they can't do that beyond a reasonable doubt, I think close. And then, of course, the judge's instructions told you should stop right there if you find him and find him not guilty. But also, the judge instructed you that regardless of whether he possessed a top prop gun or not, you must find him not guilty if the prosecution had not disproved that he acted in self-defense or defense of another beyond reasonable doubt. And in this case, there is clear evidence of self-defense of another. And by the way, I heard Mr. Kozlovic say in his summation, that's a new defense. It's not a new defense. We talked about in our summation in our opening statement a month ago. The judge gave you the instruction on it, not because he was doing me a favor. The judge gave you the instruction on it because there's a view of the evidence that supports it. Well, I had a problem, but it shouldn't even get to self-defense. But it's there. It's another layer that they have to overcome beyond a reasonable doubt. And Brother was the aggressor. There's no question. In their opening statement, they said Rocky was the aggressor. Rocky was the one who saw confrontation and taking everything possible at the trial to make it do that. Right from the beginning, they played their video of 16 East Belmore, which captured the incident. They actually left something out of that. When they claimed that Relly used bills as a human shield, what they did not want you to see was after it was all done and Rocky's out of the picture and Relly's already running out, they cut Relly running back towards Ills and attacking Ills again. So the human shield thing is no longer there. Everyone's out of the picture. And Relly goes back and takes one more parting shot at Ills to the left before he goes off to the right. They cut that out of it. Of course, they don't want you to see that. That's very damning to their case.
Mm-hmm.
Actually cut it out of their video and show that. What else did they want you to see or hear? The first shot actually occurred on the 1616 East Delmar video, which is why Detective Flores' testimony established that they mistimed the first shot. Remember, Detective Flores talked about this. As opposed to our video, which you know is the accurate timing based on 2 things: your eyes and 12. It's not a game. It's way too much to say. Your life, that's it. It's not a game. Detective Flores gave us uncomfortable testimony in that regard. Okay. It was a rough estimate, he said. They tried. That's not good enough. In a living example, how their timing was off by a full second. I showed you the video where one thing said 8 seconds, yet the video was 9 seconds. And of course, yeah, it was. But I didn't make it. I didn't make the video. let's go through the evidence that shows that Relly, not Rocky, was the aggressor. Look, you can look at three things to show that. Communications, intent, and actions. So I want to just quickly get through that and then move on. But communications, intent, and actions. Let's start with communications. The prosecution wants you to believe that the events on November 6, 2021 started the day before when Relly claimed he was in the car with Cashapp and supposedly heard Rocky say, at that end, Relly, I'll beat him up. First of all, I don't think Rocky is going to say he's going to beat Relly up in any lifetime. He's not, you know, I mean, I think Relly made fun of him, in front of his manhood, called him some derogatory names. He's not a gangster, he's not a trucker. Certainly, he's not thinking he's beating Relly up. And what's the proof of that? What's the proof of that conversation that started it all, that showed Rocky was the aggressor? No text messages, no phone records, no recorded statements, no other witnesses. And of course, the one guy who heard it, Cashapp, who Relly said he's still good friends with. They have word in here. Say, yeah, that's what Rocky said. So we just have to take Relly's word in here. Just his word. For so many reasons, you can't just take his word on anything. You saw him lie over and over to you. Over and over. It became a joke. It was offensive. It became a joke. It's not funny. Including about this very issue about being the aggressor you want to keep on. And they embraced his position on that. They embraced it. Remember what they showed you in the opening statement, text messages from Rocky to Relly on the way to the Playboy Cardi concert on November 6th, 2021 at 9:34. WYA is where you're at, where you at. Let's get through this up on my calls. They showed us this. That's the, I think, Exhibit 13. If I have that right. They showed that. They want you to believe that these were sinister messages and that Rocky, therefore, was the aggressor. First of all, you heard from 12-year-old Jamel Phillips, who said that there was nothing aggressive about these messages. He heard the calls. They were late for this Playboy Cardi concert, whatever that is. And to try to connect with Relly. But what else did you want?
Even I know who Playboy Cardi is. Hello.
When the prosecution showed you those texts, they wanted you to believe that those were the first messages of November 6, 2021. What you learned was that Relly deleted the messages before that. The early messages that showed Relly's true character, his true animosity, his true aggression towards Rocky, his true intentions of meeting Rocky that night. He deleted messages before giving his phone to the police. On November 6, 2021, at 10:30 a.m., Relly texts Rocky first, saying this. Exhibit P. You got all this fake animosity towards me, LOL, beat me up, and I wish you would. Give me a reason, and you can, whatever. You see what it says, I don't have to read that word. Relly made clear he wanted a reason to fight Rocky. He made it clear there. Matter of fact, his testimony made it clear. He said, on the trial testimony, what do you say under that tone? Give me a reason, he answers. And I say, a reason to what? Fight me, or whatever, at this point. So when he says, give me a reason, explain what that meant. It meant to fight. Fight Rocky. Those were the first messages of the evening. You didn't see that. They presented the other messages from Rocky as the only messages that day. And that one was their fault. Because their witness lied to them, lied to the police, and deleted messages. Destroyed evidence in this case. Which is wrong to do. when I asked Relly if he deleted those messages before turning his phone over to law enforcement, he lied to me at first. It was a big shocker to me. At first he said, I don't recall. Then I showed him the messages. What did he say next? His go-to line. See those messages? It's fake. It's fake. Anything that crushed him was fake.
Yeah, that's true. Even the recorded calls were fake.
In this trial, when confronted with his own words, whether in text or recorded conversations, is fake. But he ultimately admitted he sent those texts to Rocky that day. But obviously he didn't like the way it would have looked to the police, because he chose him to be the aggressor. So, it didn't fit his narrative, so what did he do? Delete them.
Yep.
What other communications were there on communication still leading up to the November 6th altercation? You saw text messages from Relly to his friend Ty Y on October 16, 2021. And Relly was in LA, as we know. And he said, if Rocky don't, this is specific, if Rocky don't do shit for this boy funeral, I'ma beat that end up. So, he's now threatening to beat Rocky up because he didn't think you've heard what that was all about this ASAP member, ASAP Josh, who passed away. Rocky stepped up and paid the lead. But he's going back to New York and funeral expenses for the family. For some reason, Relly, someone just thought, well, Rocky didn't take care of that. You know, so he would get back. He did, he learned. So Relly sent that message on October 16th, threatening to beat Rocky up. Of course, when I first showed him that message, they objected. Not sure why it's his message, because they didn't want you to see that. Threatening to beat Rocky up. And why? Why did that not be relevant for you to see?
Sounds pretty relevant to me.
That we had to bring that to you. Relly's willingness to lie to you over and over again without regard to his oath to tell the truth is offensive. When I asked Relly if he sent that message to, if he sent the message about beating up Rocky, he lied again. Pulling back on his usual answer, I don't recall. I don't recall if I sent it. So I showed him, and his response. What was his response? What am I looking at? His text messages. He said, oh, it's hard to read that for you guys. It's hard to read for me. But what he says, what am I looking at? That text? I don't recall that. I don't remember that. I wouldn't even write that, he said.
Sure.
And that's at the bottom of that red box. I wouldn't even write that. And when I explained to him that the text was given to us from his phone, from the district attorney's office, he changed his answer to, this means nothing. Even if it was okay, yes. Just like that. Just like that. Well, I don't write that. I don't write like that, too. Sir, this was given to us from your cell phone from the district attorney's office. Are you saying that's not yours? This means nothing. Even if it was, okay? Yes. So in a matter of 5 seconds, he went from, that's not me, I don't write like that, to, oh, they gave it to us from my phone? Okay, yes, it is me. That's perjury. Ladies and gentlemen, that's perjury. Again. That's a crime, by the way, perjury. So I then asked Relly, in that message that he said, if the N-word in his text message, I'm gonna beat that N up, referred to Rocky. And you know what his answer was? I don't recall. Seriously. The message said, if Rocky don't do shit to this boy funeral, I'm gonna beat that N up. So why did he say I don't recall? Because he knew that that message showed his animosity towards Rocky, it showed his aggression, and it showed his intent.
Mm-hmm.
That's why we had to bring that message up to you. We had to show you that. That didn't come on direct. His intent, number 2. Relly's messages made clear he was the aggressor. They give you a little window into his intent, but so is his testimony. When I asked him if he was upset in his belief that Rocky didn't follow through his promise to pay for Cashapp Justice funeral, Relly suddenly didn't know what the word upset meant. That's literally what he said. I don't know what the word upset means. So I showed him his prior sworn testimony at the preliminary hearing, which was also under oath. That's good for him. Question: you were upset, right? Answer: yes. So what do you do? Again, you just changed his sworn testimony in this courtroom in front of you as if it were no big deal. Yeah, I would be upset, he said. So the word he didn't even know what it meant a minute ago, he said, yeah, of course I was upset. His oath to tell the truth means nothing to that man. Absolutely nothing. Remember, he told you I could say whatever I want. And he showed you that time again. When I asked if he was, quote unquote, pissed on November 6, 2021, and he was going to meet Rocky, he once again said, I don't recall. I don't recall my pissed. I once more had to confront him with his prior statement to get the truth out of him, this time with a recorded statement to a district attorney, Mr. Siegel. No, Engel. What's his name? Engel. Siegel. Yeah, Siegel, no, that's Engel. Brett Engel from the district attorney's office back in 2022. And he said, oh yeah, I was pissed. Again, why did he first say I don't recall that he was pissed when he had said it in so many places over the years, but he didn't want him pissed. He knows that makes him out to be the aggressor on November 6, 2021. And we were talking specifically about November 6, 2021, when he was pissed. You know he was angry on November 6, 2021. You know he was now pissed and upset with Rocky. We know Relly was jealous of him. He made that very clear.
Yes, he did.
Person was Jenny. We'll get into that in a minute. He said, I made that. He used the end. I made that. You heard Relly criticize Rocky, saying it's been open-ended promises forever with him. Schroeder told you it wasn't true, that he was very generous the minute he got his first record deal. He moved everyone, 20 guys from ASAP into his apartment in New York. I heard Relly complain that he couldn't be involved with Rocky in the music industry, and that he wasn't even trying to be in August of 2021. But despite that, you saw messages in the group chat with Rocky, Relly, and Relly's business partner, this is Justin Benea, on August 6, 2021. You saw during that exchange, Relly trying to get Rocky to help him professionally, and Justin Benea asking him to jump on a call, which Rocky was happy to do, but apparently not fast enough for Relly. Because he didn't respond fast enough, Relly sent a message to that group channel August 5th, 2021, saying, exactly, here it is, exactly my point, LOL. July 24th, FU and ASAP, fake ass N, effing goofy. Make no mistake about this, Relly was jealous of Rocky and his success. He wanted the world to think he was successful. I mean, that's why we went with these Instagram posts of his, with his lavish lifestyle and his closet of cash and private planes and all the stuff he posted. However, the truth was anything but what he tried to make the world believe. So his bank accounts. I mean, he was meant to be a multi-millionaire with $700 in the bank. That was important. And that has to do with his jealousy and his greed. And there's no question he was jealous and angry about his success. And being as aggressive as he is, Relly, he didn't do much to hide his true feelings, except for being under oath. At least he tried first. He tried. Remember when he said about whether he would say F you to Rocky? He was actually asked by the prosecution on that one. Would you ever say F you to Rocky? And, you know, if you did, would you mean it? And he said, well, here's what he said. If I said F you, it was sort of wishy-washy with love. how much and try you not changing. And everything about you, you fake ass N. I get hate you, sucker. I'm not even gonna read this disgusting thing, but this is what he said. This is what he said. No, he doesn't say F you to Rocky. Only wishy-washy with love. There's nothing he doesn't lie about. There is absolutely nothing he doesn't lie about.
Mm-hmm.
That's his level of anger.
Is the judge asleep?
What was Reller's response?
No,
to his
okay.
message? Look at his response. Yeah. Yeah. I said, yeah, it's from you. Okay, that's cool. That message was cool. That's what he said. That's cool. Bless you. That's cool. In which world was that message cool for anybody? That despicable message cool for anybody? It shows you who Relly is, who he was on November 6, 2021, an angry, jealous man full of hate. Third, his actions. His actions on November 6, 2021 make it clear. His actions in this court make it clear. When I was questioning him, he became hostile, volatile, and aggressive. I mean, when he flexed his muscles, he cursed in the courtroom. Fell first to me. He yelled. And he thought I was disrespecting him by asking questions. He looked like he was ready to jump off that stand and that. And that was in front of you in the courtroom. And just imagine what it's like in the street.
Uh-huh. Very good point.
Much imagination when his actions were caught on video. Wouldn't show you that video, but he claimed he went back to the scene, by the way, to take photographs of cameras there after the incident. He said, I went back to take photographs of cameras. Well, you know if that were true, you would have seen those photographs. They didn't show you those photographs because they don't exist. They don't exist. Apart from his word, there's absolutely no evidence that Relly ever photographed a single camera at the scene. And that's because the last thing he wanted was for the police to see what was actually happening in these altercations. And listen, folks, I have to say this to you. I just hope I haven't taxed your patience by my persistence and my zeal. Yeah, I've never learned how to talk about human liberty or human faith concisely or complacently. I just don't have that ability. I just don't have that talent. And I know I'm covering a lot of material here, but I don't know like what you need here, what you don't need here. I don't know, you know, if I'm going through something you're like, yes, we know that already, Mr. Happy. I know you can't say it to me, but I just can't sit down with all that's on the line here, thinking I didn't cover something. So please bear with me. I know this is a long process, but this is my last chance to speak to you. And again, there's just so much riding on this that I just can't be brief, and I can't cut corners here. So please accept my apology that I'm going on and on, but it's important to him. And I just don't know what's important for you guys. So please.
This is really good. This is good. That's really connecting with the jury.
So, the one on Argyle Avenue, each of those two instances, the one on Argyle Avenue, the other one on the corner of East Del Mar, Relly was expressing both his anger, jealousy, and hate. And followed through on his threat just a few weeks before about, I'm going to keep that end up. Relly's testimony about his expectations on the way to meet Rocky was clear, and he was looking for a fight. And to use Relly's words, he thought if there was going to be an altercation, quote, there would be a bit of rum. In fact, although he again first tried to hide behind another one of his I don't recalls, he then admitted under oath that when men are angry, they fight. That's what he was saying. When men are angry, they fight. And despite his initial effort to make you believe otherwise, on November 6, 2021, we now know he was angry. You saw that anger on display. During the opening statement, the prosecution said that you see on video Mr. Mayers immediately is aggressive towards Mr. Efron. They showed you that Rocky is pushing Efron backwards as he pushes him off camera out of view. Well, let's see if that plays out. I'm going to show you this video.
Thank you, Ghana, for the $5 donation.
The first one reaching out is Efron. He's the first one to make physical contact with Rocky with his left hand.
Yep.
And Rocky's right hand's not even up yet. He then puts it up.
Is that Ills? Who is that?
And as Schwelby told you, consistent with that video, it was Relly who grabbed him first. And in fact, Relly realized his actions in this video were a problem for him. So although he first testified that he was a lefty while watching himself in this video, he grabbed Rocky with his left hand, he suddenly switched to being a right. I don't remember that testimony. He said, I'm a lefty, I'm a righty. You could always ask for a recap. He switched from being a lefty to a righty. He said,
Thank you,
I
Scott.
was stopping a little. Like I said, I'm a lefty. I'm a righty. Well, your left hand or right hand is not one of those things you forget. It's not one of the things you mix up. Why lie about that? Why try to minimize? Because the video showed him doing that, what you just saw, being the first aggressor, the one to make contact first. And despite the prosecution's promise about that video, it does not show Rocky as the one who is the aggressor or immediately grabs Relly. It doesn't.
No,
And
it
what
doesn't.
it does not show you the prosecution promised it to show you, which is Rocky pushing Relly off the screen. It shows the opposite, and I'm going to show you what I mean. You've all seen and heard about how much bigger and stronger Relly is than Rocky. Okay. Not a fact in dispute. Consistent with that, Schwelby told you that Relly was pulling Rocky off the screen. But you know who else told you that? Relly told you that.
Yep.
He told you I was pulling you. That's his testimony. For a standard operating procedure, when I first asked Relly if he was pulling Rocky back, he said he didn't recall, he didn't know. Then, after being impeached with his prior testimony once more, he heard his answer. He was walking in, I tried pulling him back. That's Relly at the preliminary hearing. He tried pulling him back, and that's what he's doing on the video. He's pulling Rocky back. During their opening statement with respect to this first incident, the prosecution also noted that Rocky produced a similar amount of pistols and pointed at Relly. And said, I'm going to kill you. Let's break that down. See what the evidence really shows. First of all, the object was not a semi-automatic pistol, it was a prop gun. That's pretty clear from the evidence. Not only witness testimony, the fact that there's no evidence of shooting at it. But beyond that, Rocky certainly did not point at Relly. The video shows that, and Schwelby told you that. In fact, based on Relly's own testimony, the object was put away when two people walked by on the street. And as a result of that, whatever Relly claims Rocky did with it, while they were off camera to the right, meaning inside that parking garage, that's a problem for them because they were off camera in the parking garage for only seconds. Only seconds. Not long enough for Relly to happen to him what he described happened to him. What does the evidence show about this? That he again lied to you, changed the story about what happened in that insert of the parking garage. It's not on camera. He testified here. He said Relly said that Rocky just pointed the object at his head and his stomach. Nothing more. He denied here that there was any physical contact with his body and the object. He denied that. But when he spoke to the district attorney about this in that prior recorded statement in 2022, he gave a completely different version. He said that Rocky actually pressed the barrel of the gun against his stomach and pushed. Why a different version in this courtroom? Because when we talk about this, when you're lying, sometimes you just can't keep it straight. The truth never changes. In that regard, remember what Relly first said to the desk officer, Kirk Anderson, one of the last witnesses for the prosecution, maybe his last, when he reported this incident on November 8th, 2 days later. Officer Anderson told you that Relly said Rocky pulled out the gun from 5 to 10 feet away as he was approaching. We know that didn't happen. And that's 2 days later. The video doesn't show that happening, but of course Relly first reported this incident. He didn't know that there was video. In other words, Relly could not say whatever he wanted to say, as he thinks. But it didn't stop him from trying. Then he said that Rocky said during this incident, I'm going to kill you right now. That was his word to you all. I'm going to kill you right now. Now, folks, if someone says that to you, you're not likely to forget those words. That's going to be in your mind's eye for a long time. I'm going to kill you right now as they're pointing a gun. You're not going to forget them if they are truthful. If they're truthful. But when I confronted him with his prior statement to the district attorney recorded, so it couldn't be fake. Only a year after the incident, in 2022, not 3.5 years later, like the trial testimony, only a year after, what did he say then about this? He told the district attorney on a recorded interview 1 year later. And then Rocky's like, he's saying something I don't remember because it was like a long time ago, and I don't remember what he was saying. First of all, it was a year later, and that was a long time ago. 3.5 years later, he remembers giving me death threat. A year later, he doesn't remember what he was saying because it was a long time ago. Again, the truth is not easy. Sorry, the truth is easy to keep straight. That's the truth. But when you're lying, when you're making up stories, you can't remember the lie all the time, and that's when these things happen. So what's Relly's explanation for a completely different answer on that? What's his explanation? Here's his explanation. Here's what he told you all. When I asked him, I'm getting tired of talking to everyone, bro. That was his answer. You said, Rocky said you could this jury. A year after this incident, you said, it was too long ago, you don't remember what he said. What's the story, Mr. Efron? I'm getting tired of talking to everyone, bro. That's the answer. Just in my 30 million, my 30 M's, I gotta get out of here. I want to talk about this. This is the man they want you to believe beyond a reasonable doubt. And I think we know from using our God-given common sense, the truth doesn't keep changing. It doesn't keep changing. You don't get inconsistent versions of the truth. You don't need to memorize the truth. And one last thing on this point, that first incident. You heard Twelby explain how he believed, it was his observations, how he believed the prop gun came into Rocky's hand during that first altercation. To him, anyway, the 12 would have looked like was that Rocky's sweatpants were falling down, and you actually do see that in the video. And that Relly was lifting him off the ground, and you see that. And that Rocky grabbed the prop gun to adjust it, because it had a little clip. That was Twelby's belief on what he saw in that chaotic game. You have the video to watch for yourself. Along with that video, you have Twelby's testimony. It makes it clear. Rocky was being strong-armed by Relly. No question about that. You see him being choked at one point by Relly, Twelby pointed out. He was grabbed, he was pulled, he was jostled. And under those circumstances, Rocky's actions in that brief encounter were fully justified. His Honor will give the law on self-defense. He has, you have those sheets there. The jury instructions with you, take back. They have disproved it beyond the reasonable doubt. They can't do that. That's a very heavy burden to carry. They won't be able to carry it.
Yeah, that's in your pocket.
Oh my
And
God.
you know who tells you that? Not just the video, not just Twelby, not just the video that you saw, not just Twelby. You know who else tells you it was self-defense? Relly. When Relly was talking to Wally Sajeni, at a time he didn't think he was being recorded. Remember the recordings he called fake? Here's what he said.
He tried to chest bump me. He tried to chest bump me and then pull out a gun for self-defense.
Well, so the guy wanting 30 million, the quote-unquote complaining witness in this case, the victim, is saying he pulled out a gun for self-defense.
Oh, but that was a fake recording.
But somehow you are supposed to believe it wasn't in self-defense. That's his words. That was Twelby's words, and the video shows that. That's it.
That's it.
Their own so-called victim saying Rocky acted in self-defense. How could they prove otherwise beyond a reasonable doubt? They cannot. One last thing on this: when you watch the video, Rocky held the prop in his non-dominant left hand. Her testimony, Rocky's right. The entire time, it's his left hand. Obviously, it was never meant to do more than anything but a deterrent. That thing is in his left hand all the time. Now, unfortunately, Relly wasn't deterred there. We heard about that after the first incident. You heard what happened. He followed Rocky, 12 in Hills, all the way down to Argyle Avenue, around the corner to Selma, and then we still on. Of course, when I questioned Relly about whether he followed them, he told you that he didn't. His answer was negative. Negative. So I tried to impeach him with his prior testimony, asking whether he just said it was incorrect that he followed him. And what did Relly do? He became belligerent with me, asking me, when was that? What are you talking about? Because you tripped me. Like, I don't understand. That was the answer to me. Relly understood full well what was happening. They understood full well what was happening. Because when I tried to question Relly about this, there was an objection saying that the word following was vague. Following was vague. Does anyone in this courtroom not understand the word following?
Look at the prosecution.
Don't shield witness like that. Relly said that previously under oath. They knew that.
Mm-hmm.
And despite efforts to not you hear that, Relly, you heard it yourself. Relly testified previously after the altercation by the parking garage that he followed Rocky 12 and it was followed. So why did Relly and the prosecution fight so hard to prevent you from hearing that? Because they knew that's not the act of a victim.
No, that's improper.
And certainly not the one who claims to have just been knowingly assaulted with a real gun. That's not the act of a victim. That alone, folks, is another reasonable doubt. That puts the nail in the coffin in this case. That is not the action of a victim. Following someone who just pulled the gun on you, point to the face, right to you, right to the heel. And you know it's a real gun, you're following them.
Yeah. Truth.
Not only follow them, verbally assaulting them.
Yep.
I did follow them. We'll talk about that again soon, but right now remember what Relly did as he followed Rocky over the hills. Relly was livid the entire time. He told you that, as a matter of fact. He was ready to hit 12, he said. Ready to hit 12. But only after answering, this is my favorite, honestly. Were you ready to hit 12? Correct. The court said, yes, no, I don't remember, I don't know. The court was giving them options. The witness. The witness's answer was, are you ready to hit 12? Was, yes, no, I don't recall. I don't know. Yes, no, I don't recall. I don't know. So, this is a game. Again, I remind everyone. This is their only complaining witness, their only witness to the events of that night, taking the witness stand, making serious accusations against somebody that have serious ramifications.
And a terrible witness.
And get to assess his credibility. This man can give you a straight answer, not without having pulled from him, not without having the court admonish him.
Mm-hmm.
I mean, do you remember this one? He's telling me what to do. Literally, he was telling me what to do as I'm trying to question him. That's why he was on the witness stand for 5 days. And the court won't want to say, no, don't tell Mr. Academy what to do. His job is to ask you questions. Your job is to answer questions.
There we go.
The guy was instructing me how I should ask, or what I should be doing on the witness, while I'm questioning as he's on the witness stand. In any event, Relly ultimately admitted that he was ready to hit 12. And after initially denying it, Relly also admitted he told the district attorney on 2022 and 2022 that he hated Ills. Here we all loved Ills, I told you. He told the DA 1 year later, I hate Ills. Hate. with that hatred festering in him, he followed Rocky, 12 and Ills, and he screamed it all. And why did he do that? Why did he follow them all? Remember what he said about that? Because 12 put a knife away. That's why I followed him. First of all, that doesn't make sense in any world. According to Relly, he decided to follow someone who he claimed had a gun and threatened to kill him because he saw a knife being put away. That's why he said he followed him. That defies common sense. Second, you heard from Officer Anderson, who testified in this trial at the end. He was the guy who was lucky enough to receive the letter on November 8th, 2021, and heard him say, well, he never mentioned anything about a knife when he first reported this case. In fact, according to Officer Anderson, Relly told him that 12 actually tried to de-escalate the situation. That's what Officer Anderson said Relly told him 2 days later. And third, beyond that, you heard from 12 himself. And he told you it wasn't true. He didn't carry a knife. And who are you going to believe? Is there any real question about which of them is more believable, Relly or 12?
No.
You have to assess their credibility. Their credibility is based on everything. The way they answer questions. Did they get caught lies? Were they impeached? Were they inconsistent? How was their demeanor? Relly didn't follow Rocky 12 Mills because he saw a knife. He did it because he was angry and jealous. He did it because he wanted revenge. You heard what he was yelling at as he was following him. He told Ills he was a crackhead. You heard that Ills does have some serious problems with that. You heard he said, 12 you live in the projects, mocking that whole thing. Like, how horrible. You're not as successful as me. You live in the projects. And that Rocky had failed us all. Think about that last line. Rocky failed us all. Like, he was his ward. That last line shows you there's no question of his anger and resentment. And the second altercation, and those negative feelings came to a boiling point when Relly and everyone else reached that corner of East Delmar. According to them, when they reached the corner of East Delmar, Rocky just turned around and started firing. For no reason. He just started firing. And then Relly used Ills as a human shield, he said. The evidence shows you that's absolutely not what happened. The entire time, the entire time that Relly was following Rocky, Rocky was trying to get away from him. He was verbally assaulting Rocky. Rocky never said a word. Not a word, you heard that. Relly even told you that, 12 even told you that. He was just the first one walking away. It was Relly who was acting crazy and screaming according to 12. So why would Rocky suddenly go from 0 to 100 for no reason at all, just shoot him? He wouldn't, he didn't, and it doesn't make sense. But what does make sense is what you saw for yourself on the video that we're going to show you again. And what do you see for yourself on the video? What 12 explained. That Relly was looking for a fight, as he already said. That he attacked Ills. And that Rocky fired a warning shot with a prop gun in self-defense and defense of another. And the prosecution played you a video called the sequence surveillance video. I'm going to show you that video at the end. Which placed the first shot from 6200 Hollywood Boulevard video over the 1660 East Delmar video. Before Relly grabbed Ills. That video placed the first shot before Relly grabbed Ills. That was meant to be staged, because that did not happen that way. That's not what happened. You heard from Detective Flores on this. That sequence surveillance video, that's what it was called, sequence surveillance video, it was made by hand, so a little cursor bounced around there. And it was a rough approximation, his word, rough approximation of what happened. Rough. Where every second here counts. That's a rough approximation. So when you try to put the sound into the video, it was a rough approximation. No. Rough approximation is not true beyond a reasonable doubt.
Right. You can't put someone in jail for a rough approximation. Come on.
I told you the first shot depicted would have actually occurred at a later point if the 6200 Hollywood video was fast. And what did we see the other day when he was testifying when I brought cross-examined him. We looked at that video in real time, and it was really fast. It was fast. Detective Flores said, oh yeah, one thing says 9 seconds, one says 8, you're right. So we know the sequence surveillance video is wrong. In fact, Detective Flores at that point distanced himself from it. He said, I was the one who made it. I didn't make it. Well, who did? I don't disbelieve Detective Flores. I know he didn't make it, but who did? Where did it come from? You were never told that. No one told you how they made it. That rough approximation, that turned out pretty wrong. We just threw it together, hoping that would be sufficient, and that we'd all accept that as the video with the sound, and that's the time. Hoping no one would notice the catch. We did. That's what they're trying to pass off as evidence in a crucial issue in this case. Did Rocky fire before or after Relly lunged at Ills? Because that fact changes Rocky's mindset at that moment. The prosecution wants you to believe Rocky shot first. For no reason, just out of the blue. And that Relly then dove for Ills' human shield. That's not what happened. You heard from 12B, who looked at the enlarged video that we introduced. The one with the first shot happening after Relly lunged for Ills, after Relly hit Ills multiple times. And 12B told you, he narrated that video what actually happened. You have your eyes, you see Rocky's arm go out with that first shot. And that's when the first shot is. It's well after Relly's in full-blown attack mode on Ills.
Mm-hmm.
And 12B told you what happened. When the prosecution cross-examined him, they did everything possible to not let him explain what happened. Yelled at him, demanded yes-no answers. They berated him. Anything but let him explain. They did that with 12B, a compliant witness, a respectful witness, over and over. But when I asked questions of Relly, I got speeches, insults, not answers, but I didn't cut him off. I didn't demand yes or no. If he wanted to tie the noose on his own neck, he had that. Let him keep going. But they kept cutting 12B off because they don't want you to hear what really happened.
No, that's improper argument. Fair comment on the other.
From a witness who's actually seen. That's why the prosecution and their case detectives didn't even try to speak to 12B. The 3 1/2 years, they knew who it was. They knew where he lived. 3 1/2 years, they didn't try to speak to 12B. Yeah, two weeks before the trial started, or no, sorry, not even. As the trial started, they asked in court with the judge, if you want to speak to us. He was like, nah, I'm good. Okay, the trial had already started. He was a witness. 3.5 years, they didn't even think to reach out. But they tried to make it think otherwise. They asked Detective Flores on direct whether 12B would agree to an interview. Detective Flores said no. That was it. No. Which would leave you with an impression I would understand that 12B was not cooperative. He didn't want to speak to me. What you learned on cross-examination that Detective Flores only first tried to speak to 12B a couple of weeks ago in 2025.
This goes to Patty's point.
Come on. I asked Detective Flores, is January 2025 the first time you tried to interview 12B? About what happened on November 6, 2021? His answer was, correct. Me personally, yes. So I had to follow up that one with you personally. When you say you personally, how about anyone else from the police department? His answer was, no, that would be the first time. Can you, Detective Flores, seriously think I was just asking about him personally? Of course not. That was devastating to them. So I had to go through 3 layers of that. Oh, here it would be. We're putting it up in that. Well, why? It was off. It's a nice beach. It was a beach anyway, ladies and gentlemen. That's what proof it is. said, yep, that's what he said. 12 would agree to be interviewed by you, and you said no, he wouldn't. Remember? Yes. Are you referring to 2 weeks ago in court here? Yes. Is that the first time you tried to interview him? Yes. So in January 2025 is the first time you tried to interview 12 about the incident that occurred on November 6, 2021? Correct. Me personally, yes. How about anyone else from your police department? Yes. No. That would be the first time, correct. Why did I bring that out on cross? Why? Search for the truth. Why is that not all coming out on the record? As opposed to leaving you with the impression if I decided not to get up and cross-examine, well, I was asleep. You'd be left with the impression, fairly, that 12 was not compliant, he wasn't cooperative, he didn't want to speak to me, he refused to be interviewed. That's not the case, as you see. And they had told, 12 told you what happened. His testimony is consistent with what's seen on that video. Look, that's defense exhibit E, and I will say this, thank God there's a video. Thank God there's a video of these still on. Before we play it, hold on. When I was listening to Mr. Frisloma's summation, the first summation that they get, it was as if he never saw this video. This is the exact right time of what happened. Based on the video, based on 12B's testimony, based on the detective Flores saying that their video was a second too fast. You see Relly throwing haymakers in this video. Haymakers is from expression. Punches. Repeatedly. Let me show it to you. Then Mr. Frisloman said in his opening statement, in his opening summation, that I said in my opening, that I promised you I was going to bring in pictures of ills to show you. Ladies and gentlemen, I don't make promises I can't keep. And I promise you, I never said that in my opening statement. As a matter of fact, they get to go again after I film. I will not object if they put my opening statement up.
No, that's improper.
Sustained. Sustained.
Show me anywhere where I promised pictures of ills. I never did. But that was argued to you yesterday. And why would they take pictures of Ill's bloody lip on November 6, 2021, just in case there was a trial in 2025? Okay, let's watch that defense exhibit EE. You'll see everything 12 described in the video. That Relly acted as the aggressor, that he repeatedly hit Ills. Only after that, Rocky tried to defend Ills by firing the first warning shot. Sergeant Cook sort of suggested on his body cam. You see his arm extending to fire the props when you hear the sound. It's clear and obvious. You had a live witness who was over there. Let's look at it now. This is the REE. There's Rocky, there's 12, there's Ills, and there's Relly. And you see him going after.
You can actually hear the gunshot.
See Relly still going after Ills. Still going after Ills. Rocky's gone. 12 is about to go. Ills is stuck in the upper left-hand corner there. Watch Relly go back after him one more time left before he goes right. Ills running away, he falls. And then Relly goes off to the right. Now, we have to break that down a little slower. It's very fast what happens. Again, guys, when you're deliberating, you get to see this. Judge, they back in the room with them? Yeah?
What?
Does this get to go back in the room with them? Yeah. Oh, good. So, you can see as much as you want, as long as you want, as slow as you want, as fast as you want. But look, that didn't stop Relly. I'm not going to yet. What you see is him repeatedly hitting Hills, move towards Schroby, and try to hit him. And look, you see Relly literally cocking his arm back and slugging Hills. I'm going to try and show it to you here. I'm going to get that pointer. I'm going to sit in this chair so I don't block you all in the back. Can everyone back there see? Yep, big head. Okay. Wow. gentle on the screen. There's Rocky. There's
Okay.
Trophy. There's Ills. And there's Relly. And boom, he's going after him. Look at him. He's tussling and there's the first shot. There's the second. And look at his arm going back and forth here. Can you go back for a second, guys? Look, you can see the arm going back and forth. Go back one more second time, guys. A little further.
Whose arm is it though?
Watch his arm. Boom, and you see the head of Ills there, going back and forth.
Oh, okay.
And why does 12 tell you he ran? One more time, guys, please. He said he sees Relly coming at him, and he has that something hernia, inguinal hernia, whatever that is, and he couldn't fight. Watch. He's right there. Then he sees him coming, and he runs because he can't fight. Look. It's over.
They
Why is
keep
he still
fighting.
And he just knocks those down. DA cuts off this part. Boom.
Oof.
One more. Good graces, and then he goes to the right and leaves. Well, the good news is you get to take that back in the video. The jury, I know that. So that's good. You can see it as many times as you want. Whatever speed you want. Stop wherever you want. I encourage you to do that. That's the fence exhibit E. That's the right time. You see, Jack, we do one more time, just that shot part. It's out, it's what Trolley told you, but again, you have eyes. Rocky's arm goes like that. That's where the shot is. I really described that. That's what he's doing. He's shooting down, he said. It's after Relly attacks him. Boom, he's hitting Ills. Boom, and you hear the shot. Ladies and gentlemen, there's no real question that Relly was the aggressor here. The video from 16 Visa Del Mar makes that perfectly clear. Perfectly clear. The real video, not the rough one that was off by a second. That makes the shooting all look ridiculous. I mean, their video, you hear a shot, and then Rocky shoots. That's the video that captures what happened. Totally narrated for you. Your eyes can tell you. He wasn't using Ills as human shield. He wasn't underneath or behind Ills. He was on top of Ills. That's not how you use a human shield. And Trophy told you that he told Rocky to leave because of the noise, because of his status as a high-profile person. And Rocky ultimately left, but still, after that, Relly continued to attack Ills.
Mm-hmm.
They, as I mentioned to you, they cut off their video, so you didn't see that anymore. I'm hoping no one will notice. Let's play their video real quick. Can we play theirs? This is their video. Watch what is cut off at the end. Rocky's going. Chloe said he's checking to make sure it was okay. Then he runs. That's it.
That's it. Ooh, they did cut that. Ooh, they did.
16 Visa Del Mar. 16 Visa Del Mar is cut off. Go back one more time, just where it gets cut off. Combined surveillance video. That's the one. What you know happens next is Relly, they're out of the picture now. Relly goes back and hits Ills again. 12 describe it for you. Why did that not make it into this video? Go ahead.
Great question.
Boom. And I think this chair is little. There's a nail sticking out, by the way. Just so you know.
Judge does not give a shit.
I know that wasn't you, John. That one I don't blame. Is there a bill I can send for this suit that you sent? Literally, it's a nail sticking out. Anyway, don't worry. Don't be sitting there. Oof. Not good. Okay.
I hope his pants aren't torn.
Anyway, the video, folks, the video itself by itself is reasonable doubt. It's a reasonable doubt in this case. another reasonable doubt.
He's watching the clock.
He just makes clear that their case does not hold water, that Relly was the aggressor, that Rocky acted justifiably in self-defense bills. Even though he was carrying the prop gun, those ills will be dead. That was a real gun on that second shot. And again, the judge gave you trust no self-defense. I have to discuss it with you. What matters is the defendant's perspective is what matters. And what he thought was right at the time. Judge gave you instruction on that, reasonableness and all that stuff. You have to listen to that. The prosecution must prove beyond a reasonable doubt that he did not act reasonably, Rocky. And have to prove beyond a reasonable doubt that he did not act in self-defense of another. If you have any questions in your mind as to whether he acted in self-defense or defense of another, if you have some doubt or some concern that he just may have acted in defense of himself or another, you have to stop. Not guilty.
It's a great statement of the law. It's true.
Does it say you are?
Yeah, it's what you said. It's not
I'm sorry?
what you said. It's not accurate. Here's a jury instruction that's already been given to you, and this applies to everybody. You must follow the law as I explain it to you, even if you disagree with it. If you believe that the attorney's comments on the law conflict with my instructions, you must follow my instructions.
But I think I understand what Mr. Lewin's objection was. He actually was right. I said some doubt. It's not some doubt. It's a reasonable doubt.
That is right.
It's a reasonable. Okay. Thank you. No swallow. So if you have a reasonable doubt that he may have acted in self-defense of another, you have to stop. Okay? And the judge, again, will define to you what that is. Even if you get that far, which you should, because the evidence is overwhelming, that was the problem. If there's a possibility he acted in self-defense, you must find another. Rocky, now we've got to address this. Rocky didn't testify in this case. When you heard the judge's instructions about that the defendant has a constitutional right not to testify, we spoke to somebody in the jury selection about that. And that decision is not to be considered during your deliberations. With that said, during your deliberations, keep in mind that there was nothing more said than what was already explained to you by both our witnesses, who were berated and yelled at for a long time. Hours. You heard from 12B, who explained what happened that night. And Rocky carrying the prop gun. You heard from Lou Levin, who explained how Rocky got possession of the prop gun, why he carried it, and where it went. There was really nothing more, aside from the video, 12B and Lou, for Rocky to have added to the truth about
Well,
what
that's
happened.
an improper argument. It's just that.
Well, look, by the way, with regards to 12B and Lou, you heard people say, and I expect they will say it again, the first time that we mentioned the prop gun was during this trial. Here's Detective Flores' testimony when they tried to ask her that or suggest that this had just come up. Question to Detective Flores. No deposition in criminal cases, correct? Okay. Question. So basically, what you were being asked are questions related to discovery disclosure in a criminal case. And you said, yes. Okay. So these discovery-related matters, and because they didn't receive discovery notice, is not the same as it just surfaced at trial. Like it was just invented. That's not true. Lou and 12B they told us about this last year. And of course, Detective Flores told you law enforcement didn't have a chance to speak to Rocky after he was arrested. And of course, there's no idea.
That's that mistakes here.
No, it didn't say they didn't have a chance to.
Do not debate.
You just said mistakes here.
All this objecting
as I
during
said
closing.
yesterday, I don't know what the evidence is. I don't think anybody remembers every word of every witness. If this is something significant, as I mentioned yesterday, you can ask the court reporter to read it back. The court reporter will have every word that has been spoken. Go ahead.
Anyway, of course, Detective Flores had no idea what was said by Rocky to his attorneys back in 2022 when he was arrested. And ever six.
That's also improper argument, overall side of the evidence.
It's so wrong to object during closing.
There's absolutely nothing new, as they're trying to suggest. And look, they also brought up something that I now have to address, that Rocky had an outburst, so to speak, in trial. Okay? Knowing that he's innocent, he had to sit here and listen for more than 3 weeks, listening to
No,
relevant.
this is improper argument.
No, it's addressing what Mr. Krislovic had brought up in his argument.
The objections are
He had to
ridiculous.
sit here for more than 3 weeks, listening to Relly say the most horrific, most offensive things about him in messages, calling him horrific names. He didn't say a word. He sat in silence. Always composed and respectful to this court and to you all. At some point during a minor, unrelated question, unrelated to November 6, 2021, Mr. Loon was asking 12E the meaning of an acronym in Rocky's bedroom. Rocky did something was a crime of sin. Don't say. It had to do with his kids. It was personal to his children. And he asked not to say, okay. He regrets doing that.
Your Honor, there's no evidence of this.
Can you read that back?
These objections, you guys, it's terrible. And if I'm on the jury, I'm like, let's move it along, guys. All right, like.
Rocky did something that it was private, said don't say it, it had to do with his kid. It was personal to his children. He asked him not to say it.
Overrule the objection. It's ridiculous.
The jury heard what the question was. The jury heard what Mr. Mayers said. Leave it at that.
That had absolutely nothing to do with the facts of this case. The truth, what happened on November 6, 2021, whether he carried a prop gun, he didn't commit a crime. And the fact that they actually argued that to you in their summation is indicative of just how desperate they are at this point.
Agreed.
That was something worth mentioning to you in their summation. Let's talk about the crime of extortion by relative. That was actually proven in this trial.
Let's hurry up, though.
Improper argument, overall, for legal conclusion, crime.
Overruled.
I love it when the
That's
judge
why
yells at him.
Rocky told Relly in a text message that night, go to the police. Go to the police. But Relly didn't, not until he got civil lawyers 2 days later, because it was never his intention to go to the police. You heard that loud and clear. And said his end game was always to take Rocky's money based on false accusations. That was always his intention. And that's why that night, instead of getting the police involved, Relly, according to him, with his shell casing that he claims he found, texts the photos of his shell casings and knuckle scrapes to Rocky's manager, John Heyman, saying he was going to be rich. And that following message was sent to his own business partner, Justin Benea, saying, I want to get this end's money within minutes. That was in his mind. And you heard Relly complain in bitterness how Rocky didn't give him opportunities. So when the opportunity presented himself on November 6th, presented itself on November 6th, 2021, Relly jumped all over. Right from the beginning, Relly tried to get Rocky's money. Right from the beginning, without going to the police, without even going to a civil lawyer. So you heard from his own mouth what he knew that to be. Words so catastrophic to his claims in this case that his immediate reaction was to lie and say the tapes were fake. Fake. Get those away from me. You have to tell me Nora. Fake. Look.
So you called him because we were presenting fake evidence to you? Yes or no? I don't know. This is a wonderful. Does that rile you guys to keep playing fake audio to like fake stuff? I never said none of that to him. It doesn't even make sense. It doesn't fit in with his case. You're trying to slip it in. Okay, stop. All right, let's answer the question.
Fake audio, folks. Fake audio that the district attorney played yesterday with the Durella Farm name next to all his quotes. And the Durella Farm was sitting here yesterday, he'd be screaming, "Those are fake!" during Mr. Brzomic's summation. I heard Mr. Brzomic say in his summation, who cares what he said to Wally? Who cares? Did he forget the import of that conversation? That he committed perjury to you? And said that they were fake when they were real? And you know, during the cross-examination of Wally, the guy flew from Paris, by the way, on a subpoena because he had to be here. Okay? Literally, a 13-hour flight to testify and then take another 13-hour flight back. And the question was, you flew business class, didn't you? Like, as if that were the reason he took 26 hours of plane to get here to testify. I had him on direct examination for 10 minutes because he was here for two things. Do you know anything about this case? I know nothing about this case. Good. Is this tape real? Is that, do you make it? And is that your voice? And is that Rolly's voice? Yes, it is. Bye-bye. Have a good flight back. No. 2.5 hours on cross-examination.
Crazy.
But you know what was never asked on cross-examination, not even once? Is the tape fake? Is the tape fake? Did you doctor the tape? Not even once. By the way, the tape they spent, I don't know, the portion of the summation playing for you yesterday, we provided to them. We provided them that tape. They think it's so helpful to them. They know those tapes are dead. Dead to their case. First of all, their main witness once again committed perjury on a most important issue in this case. Those are fake. He said fake. Get those away. He's a clown. Those tapes are death to Riley's claim and his credibility in their case. As Wallace and Jimmy made clear that anything but fake, you heard Riley tell him that you ask for a bag without a lawyer, bro, it's called extortion.
You know what I'm saying? You ask for a bag without a lawyer, bro, it's called extortion. You feel me?
Well, that's exactly
You
what
do everything accordingly.
That's exactly what Willie did. Because he didn't have a lawyer until November 8th, 2021. After he already tried to ask for money from Rocky and his manager. And after Willie lied about what he just told Wallace and Jemmy, we called Mrs. Jemmy just to establish the authenticity of those recordings. Nothing more. He knew nothing about this case. And because of the evidentiary rules, we were only allowed to ask Mrs. Jemmy about statements that Willie denied making.
No, that is untrue. Overruled.
Unbelievable.
So we had those 5 questions that we had asked him. Did he say this? Did he say this? Did he say this? That's the prosecution played other parts of the recordings afterwards. And it wasn't a gotcha moment. It's reading those tapes. At the time of their discussions, remember this, the Wallace and Jemmy discussions, that was in 2022, after Rocky's arrest already, after he filed his civil suit. Really. They were about the events of November 6, 2021. They were of no significance at all what Relly said to him at that point regarding November 6th, at all. Because he had already been arrested, Rocky. Relly had already been telling his story for months. His fabricated story for months. So that he said it to Wally on a tape makes it more true. If you tell a lie 100 times, it doesn't make it more true. So in an effort to give weight to that story about the incident, those recordings, they played it. Rocky was already arrested and he had already had a civil suit, claiming permanent disabilities from a bullet wound, and he needs $30 million.
Permanent disabilities from scraping his knuckle.
He really said well, in part. He still had no qualms lying to Wally at all on those recordings. When it suited him, of course, telling Wally that he was a millionaire and he made Rocky's career, that was on those recordings too. That wasn't true. Neither of those things. But when Rowley didn't lie, about, however, what he didn't lie was about his intentions to take Rocky's money, which is why he falsely said the recordings were fake. He knew what was coming. And he just said, I say they're fake, they can't play it. They're fake, get those away from me. Eleanor said, get away from me. So while this Jimmy was an IT guy who came for one reason, authenticate tape, period, end of story.
Got 10 minutes left.
First question I asked him, do you know anything about the facts of this case? No, I don't. He was not brought in here to talk about the facts of this case. But the prosecution, in 2.5 hours of cross-examination, asked him about his motives for making the tape. Is he better friends with Rocky? That's not being a very good friend to Relly. It doesn't matter what he made the tape. Who cares? He could have, whatever his motives were, who cares? He made the tape. It was real. Those were really Relly's words that he said were fake. Whatever his motive was is irrelevant. Even if he wanted to help Rocky, he told you that's how it was, is that Relly was trying to get involved, he was falling, whatever. But whatever his motives were, does it make the tape less real? Or Relly's statements less real? He was never asked one thing about those recordings being real on cross, which means they accept the fact that their witness committed perjury to you when he said they're fake.
That's improper argument.
Fair comment on your.
That should be offensive. And especially to you, the jury, trying to make a decision of such importance in this case. It's a lot on your shoulders. That should be, you should be offended by that, I would say. So what did Relly tell us on those messages? His earlier text messages to Rocky when his manager, when they were trying to get money before his lawsuit, that he never cared about the police. He still doesn't care about the police. Quote, the end game, I'm suing the shit out of him. That's my end game regardless. I don't give a F about no police and those two words on the tape. In fact, Relly only went to the police after his effort to extort Rocky failed, and Relly's civil lawyer said, unless you go to the police, I'm not taking your case. That's why Relly showed up at the police station in Hollywood with a civil lawyer standing next to him 2 days later. What victim of a crime was the police station report a crime with an attorney next to him?
I do. I don't talk to the police without a lawyer.
Judge, you want to do it now? Bert?
If you have 2 more minutes, you
Go
do
ahead.
that, otherwise you
Sure,
can break.
Yep.
Say again?
I'll do 2 more minutes. Just tell me when to stop.
Then we're going to take a
Yep.
break.
As a quick aside, you heard, by the way,
Wrap
the
it up, buddy.
prosecution questioned Relly about telling the police he heard 3 to 4 shots, but only giving them 2 shell casings before having seen the videos, as if somehow that makes him more credible. That makes no sense. He was there, of course. He knew it was 2 shots. By this time, he already saw the video. He knows it's 2 shots. And in fact, he would exaggerate when speaking to the police. Does not make him more credible. By the way, when we talked to Wally, he had up to 5 shots.
Yep.
He had up to 5
Good
shots
point.
when we talked to Wally. So before Relly went to the police, even before he went to a civil lawyer, you saw the messages he sent trying to get Rocky's money. Part of his plan to extort Rocky, Relly sent a text message to him, falsely accusing Rocky of trying to kill him. Obviously, Rocky knew that was false and was shocked that Relly would even make a claim, so which is why Rocky wrote him back. I tried to lie. Stop making shit up. He wrote him back. And now the prosecution has alluded to the fact that during this trial, Rocky didn't mention in his message anything about his prop gun. They don't consider one thing, though, about that. They don't consider one thing. Unlike Relly, Rocky didn't have a reason at the time he sent that message about stop making shit up. He didn't have a reason at the time, or think he needed a reason to create a record of events for some later date.
Mm-hmm.
At the time he sent those messages, Rocky thought they were between the 2 of them. And he knew why Relly understood his claim wasn't true, because it wasn't true. Rocky didn't shoot him and was aware that Relly knew he didn't shoot him because a shotgun doesn't shoot bullets. A Star pistol doesn't shoot bullets. Yes, sir.
Stop.
Okay.
You want to finish the thought?
If I could, just a thought.
Finish the thought, and then we'll take
And
the
then this is a perfect place to break it. And that's why after learning soon thereafter that Relly was contacting his manager trying to extort money from him, Rocky was done communicating with Relly. He stopped answering completely and said, go to the police. And what kind of person tells someone to go to the police if they know they've committed a crime?
Exactly.
I could resume from here and we'll come back.
All right, we'll take a break
Close the end.
until 11 o'clock, folks. Please make discuss the case amongst yourselves and everybody else. And we'll see you in 15 minutes.
Oh my god. Oh my god. These lawyers have given what I would call the world's longest closings. The prosecution's closing was like 3 hours or something. Now this is like we've just sat through an hour together, and then there was like 2 hours yesterday. I mean, come on. Hopefully they kind of cut through things and start moving. The judge made it very clear he did not want to come back to this case on Tuesday, okay? They have Monday off for President's Day. We don't, but they do. And the judge was like, if you can't make a decision by Friday, then you have to come back Tuesday. The way the judge presented that information was friggin' hilarious to me. All right, I'm going to unmute it, kind of run it quiet. Oh, JK, hold on.
Do not mention the prosecution first. Here's a quote. On an objection, you overrule it. The prosecution accepts their witness committing perjury. It's improper. It's unethical. You said you're not going to tolerate it, and I object. And you make it clear to the jury that my objection you find annoying. It's very clear that the tone that we get when we make an objection that should be sustained is, what are you doing? That's what was said. You specifically...
Lower your voice and don't yell at me. I told you before. I'll listen to what you say. Speak in a normal tone of voice.
Judge, we're doing the best we can to make sure that this trial is ethically conducted. They have repeated, I've objected, you told them it's improper. You overruled repeated objections where they are saying improper things. He just said a moment ago, this is a direct quote, the prosecution accepts their witness committing perjury. I object. You respond, that's appropriate comment on the evidence. It is not appropriate comment on the evidence, Your Honor.
Yeah, it is.
I don't know if you didn't hear it.
I didn't hear that.
So, Judge,
What I heard, I could have been wrong, what I heard was that Mr. Tacopina was describing Relly as committing perjury.
Judge, that's a direct quote. The direct quote was, the prosecution accepts their witness committing perjury. Here's another one. Relly committed extortion. There is no legal...
Do you think the jury's going to ask for what the legal description of extortion is?
Your Honor,
Forcing someone to pay money, that is, quote, extortion.
no, Your Honor,
Forget, go on to something else.
Your Honor, I want to make my record. I mean,
That's a tally.
But I have a right to make my record. No lawyer can get up here. No lawyer can get up here and tell the jury that a crime has been committed when there is no instruction on that crime. When in fact, Your Honor, that's not the legal definition of extortion. We've objected, and the court again is basically telling me, don't worry about it, it doesn't matter. Your Honor, it does matter. After a while, when there are so many of these things, they add up. And when the court is saying, wow, what they don't care about it.
No, I didn't say they don't care about it.
It seems, Your Honor, it's improper argument. And the problem is
I don't agree with you. I think using the word, quote, extortion to describe the conduct is not improper. I think it's fair comment on the evidence. You, in your rebuttal argument, you can say it wasn't extortion. You can address it.
Your Honor, the bigger issue, as I said, is the court repeatedly told us, do not connect the prosecution to committing crime.
I'll tell you what, I didn't hear that. I'm going to ask Kathy for the exact quote. If that's what was said, I'm going to sustain your objection, and I will apologize for overruling.
Judge, can I respond, please, on that one issue, not
Yeah.
everything else you said. What I said was, and I agree with what I said, but understand the context of it, okay? I didn't say this more perfect. I didn't say it yesterday, I didn't say it today. The one thing I said, and it was fair comment, was the prosecution accepts their witness committing perjury. And what I mean by that is in regards to one thing, and it's indisputable, Your Honor. It was regarding Relly saying the tape was fake. The tape was fake. They got up, cross-examined Mr. Sajemi, did not ask him if the tape was fake or not. Okay? They then put up transcripts of that tape recording with attributions to Mr. Efron. So that means just by that very fact, they accept the fact that
Agree.
he committed perjury. I'm not saying they support it, but they accept that witness committed perjury. They have to. Let me finish. There's no other way for them to move forward unless they say that wasn't perjury, but it was because he said that was fake. We know it wasn't fake. It was real. That was perjury. So by then moving forward with it, arguing that the tape is important for the prosecution, that Efron said these things, that when they cross-examined Sajemi, that wasn't being good for Efron to create a tape. All that is doing is, I'd say this is warning. It's different. I would never say that. I didn't say it yesterday. What it is doing is accepting it, because they didn't say, we have an issue with this witness. He's committed perjury.
Right.
I said they accepted their witnesses committing perjury. That witness committed perjury on that one issue. That's fair comment, Your Honor. It's not inappropriate. It wasn't disparaging counsel. I didn't say Mr. Lewin. I just said they accepted, and that is true. That there's no other way around it.
Yep.
It is not fair comment. It is completely unethical.
I agree with you.
So, Your Honor,
I agree with you.
What's frightening is Mr. Takina just stood up here and basically defended, said, yeah, I said it, but I can say it. He doesn't know or care about the law. That is clear. And Your Honor,
Oh, my
it's
Lord.
happened 25 times in this trial with the hiding of evidence, with the late discovery, and with repeated. You told counsel before we started, do not disparage the other side. I said yesterday, you argue what you want about witnesses. You said a witness lied. You do not disparage counsel. You repeated it yesterday. He tried to explain how he didn't make mistakes yesterday, which he did. Now he gets up and he's now admitted, yes, I made that comment, here's why it's appropriate. Your Honor, it's not appropriate. It's completely unethical. It is immoral, and it's not professional. And again, Your Honor, the fact that he is getting up here and saying, well, yeah, I said it, here's why, just demonstrates again, he doesn't know the law or doesn't care.
You're disparaging him, right?
Yes. Yes, he is.
I'm disparaging him because, Your Honor, he's not following the
There
rules
is not
of
to be
conduct.
any disparaging of either side.
During argument, the jury's not here. I have every right, obligation, and duty to stand up here and point out that he was being unethical. The first time the court catches me being unethical, Your Honor, the court knows. That'll be the first time. The court knows. I don't do that.
Oh, my God.
Court knows. Court's already made
I've heard enough from both of you. I missed the prosecution accepts their witness committing perjury. I don't think that's fair comment on the evidence. I think that's an improper statement. It infers that the prosecution is allowing perjury to occur.
They did.
I'm going to sustain your objection, and I'm going to apologize for overruling it, and then move on. If I were the two of you, I would just move on and not make bring it to the jury's attention. I would point out, though, I told you at the beginning of arguments that if an objection is made, I'm going to do my best to call it as I see it. You have made 17 objections. I have overruled 12. I have sustained 5. I'm doing the best I can. I will continue to do the best I can, and that's all I can say.
I just want to put on the record that these remarks about being unethical is not just about had it with him. This from a lawyer who, and I was saying yesterday on it, this from a lawyer who asked in front of a jury for a stipulation that a shooting range was not in California when either he knew it was in California or had no idea that it was in California. Okay? So he literally asked for a stipulation in front of a jury that he knew was not true or didn't know if it was true. And that's unethical.
Yeah.
That's unethical. And this is a guy who, the Ninth Circuit just said lied to a jury in the Brantford case.
Your Honor,
so
Your
I
Honor,
want to hear about him.
one more thing out of him, and we air everything that's happened in this case, which the court's aware of.
Stop.
He might want to stop.
I'm so threatened.
You should be, Joe.
Let's take a break.
You should be.
The appellate court's ever told me I was a liar.
Hey.
Oh, yeah. I'm so scared of you.
Stop it!
Oh my God. judge. This shit is wild. Rocky looks great today, by the way. I freaking love that suit. Oh my goodness, I love his suit. Y'all. Holy shit. Oh my god. Oh my god. Oh my god. That was absolutely hilarious. You should be threatened. Oh, okay. Did a police officer just witness that? Can we prosecute this man? Holy hell. Y'all. Whoa. I mean, that prosecutor is out of control. That dude needs anger management classes. He and Relly should be put in anger management classes together because boy, oh boy. Now, I do agree that the defense attorney doesn't actually know the law because he's terrible at objections. My God, he's never given like a legal reason for an objection at all. But how do you object 17 times during someone's closing? 17 objections? It's tacky. It's tacky. It looks desperate. The jury's going to see that. Patty asked if I think it's going to be guilty or not guilty or hung jury. I can't see how this jury could find him guilty. I do not see evidence beyond a reasonable doubt at all. At all. All right, so let's go back to 12E while they're on break. I have the sound in the background, so I should hear it when they come back. And we'll get back to 12E.
And you would agree, you're aware that the defendant still speaks deals, right?
I believe so. I'm not too sure.
Well, when you're not too sure, you're saying you have not had a conversation with the defendant where the two of you talk about ills?
We don't talk about ills, but we have been in family events, and ills have been there.
So it's your understanding that the defendant continues to have a relationship with ills, correct?
Yes, we all friends, yes.
And you still continue to have a relationship with ills, correct?
That's my friend, yes it is.
Where's ills today?
Sir, I'm here. I'm not too sure.
Let me ask the question again. Where does ills reside? Where is he today?
That's not what he asked.
I'm asking, Your Honor, I can't, lax person, I'm asking if he knows. There's a lax person.
No, you didn't ask if he knew.
Yeah.
I know you asked me where is it.
And he, do you know where ills is?
No, sir.
Where is the last time you knew ills to be?
In New York City?
In New York City. When was this?
Sir, maybe November.
November of 2024.
2024, yes.
And you are aware that Ills is aware that the defendant's been charged in this case, correct?
Objection.
Speculation.
Have you ever had a conversation with Ills, by text, in person, etc., regarding the defendant's case?
No.
Has Ills ever said to you, at any point in time, that he is aware that his close friend, Cashapp Rocky, has been charged in this case?
I never had this conversation with Ills, I'm sorry.
So you've never had, since this incident happened on November 6, 2021, you've never had another conversation with Ills about what happened?
We spoke the week of, and it was just the fact that, it was sad that one of our brothers had a fight with another one of our brothers. So that was it.
And you've never spoken to Ills about what happened since that point in time?
No.
Is that correct?
That's correct.
Who's Wally Sajini?
Excuse me?
Wally Sajini. Who is he?
Well, I believe he works as I guess a liaison for different, I guess like tech companies. I'm not too sure.
He's also known as ASAP Wally, right?
No, he's not.
Isn't he a part of the collective?
He's not a part of ASAP.
Is he a part of AWGE?
I'm not too sure. I feel like he could just be an independent contractor. I'm not sure of his business.
Are you a part of AWGE?
I am a part of ASAP.
Are you a part of AWGE?
No, I'm ASAP.
What's AWGE?
I don't know.
You've never heard of AWGE?
I've heard of it, but I'm not too sure like what it is exactly. Like a creative agency.
What do you know it to be?
I know the person that's involved with it is a creative person, and just to me, it's a creative agency.
Is the defendant involved with AWGE?
I believe so.
Well, when you say you believe so, how do you know? What are you basing it on?
Just from his creative curations.
Just based on, sorry?
Creative curations. So
What
it's
is
a
that?
creative agency.
Would you agree, let me back this up. Are you aware that Mr. Tajimi is someone that regularly speaks or texts, has contact with the defendant?
I'm not too sure what he does.
So you don't know?
No.
How often do you have contact with Mr. Tajimi?
Maybe once every 3 months.
And when's the last time you had contact?
Last year he was trying to help me get like something with sneakers. I'm heavy into sneakers. He was trying to get me like a mocking situation.
You said you watched some of the testimony in this case, previously testified that, do you recall?
Only like what I've seen on clips on the internet.
Well, so I assume you've seen clips on the internet of Wally Tajimi's testimony, correct?
Actually I only seen his thumbnail.
His thumbnail.
Yes.
What does that mean?
Just a photo of him with his leg crossed, just looking at you.
So you didn't see, you don't know any of his testimony at all?
No.
I want you to assume for a moment that Mr. Tajimi testified that he was mediating the dispute between Morelli and the defendant. I want you to assume that he testified that. Did he ever reach out to you, Wally, to talk to you about what happened so he could effectively mediate the situation?
No.
Have you ever spoken to Mr. Tajimi about what happened on November 6th?
No.
Were you aware that he was, quote, mediating the situation with Morelli?
I was not aware.
You would agree that Mr. Tajimi is much closer to the defendant than he is to Morelli, correct?
Well, possibly.
When you say possibly, you mean yes, correct?
I haven't seen Wally in years, sir, so I'm not too sure like what you were trying to explain to me. I haven't seen Wally.
Have you ever spoken to Mr. Tajimi about Morelli's lawsuit or about the criminal charges in this case?
No.
I want to talk about social media for a second. You're on the left board now? Because it's unusual. I will finish under my 2 hours. I know the court had me over, but I just wanted to put that out. I want to talk about social media for a second. In your industry, you would agree that sites like Instagram and the personas they are creating, those are not necessarily meant to reflect reality, correct?
Yes.
So you agree?
Yeah.
Yeah, so in other words, you have somebody, individuals in your world, they might be posing with money, guns, planes, women, etc. And just because they're posing with those items doesn't mean that, for instance, the plane or the money they're posing with is theirs. Is that right?
Well, it could be theirs for the moment, momentarily. They rented it or paid their way to get on there or whatever.
Right, but you would agree that Instagram is used by individuals in your field to create an image, a persona. And sometimes that persona might involve, they want to look really wealthy, right?
As far as musicians,
As far as anybody in the ASAP world, or anybody in the rap entertainment world.
nah, I don't know. That's a broad comment because not everybody in the rap world is into planes, chains, cars. I like books.
Okay, that's not what I'm
God, I love him. Oh my God. 12E, if you want another career, holler. I will help you. Okay? If you want a girl to talk to, give me a call. You are amazing. Hilarious. Oh my God. I like books. What the prosecution's trying to do here is rehab their witness who was proven to lie by way of Instagram, right? And any kind of lie that a witness tells is not great. So the prosecution is really trying right now to rehab their witness by showing that, you know, Instagram is fake land.
What I asked you was private planes or what that's created on social media, correct?
No.
You would disagree with
Yeah, I
that?
would disagree.
So in all of your posts, have you ever posed with items in your Instagram, whether it be money or physical items, plane, cars, etc., that you didn't actually own?
Unless it was for a music video, no.
Well, the music video would be the same thing, correct?
A music video is meant to be art. It's meant to be like a movie.
Okay. So, it's your
Great.
testimony that you believe that when an individual, so as an example, your position would be that if Relly has on his Instagram a bunch of photos of money or of a private plane, then he is basically saying to the world, that's my private plane and that's my money, and it's like he's testifying in court when he doesn't. Relevant?
Also speculation. Okay, I went on 12E's Instagram. He does have pictures with cars. That's from 24. Then here they're sitting on the car. Okay. Here they're hanging out as a group. That's all from April of 24. His newer stuff, I mean, there's definitely like, it looks like he models or does something for different brands. Okay, here he went to Korea. Okay, that was in September of 24. The other items when I look on his Instagram that appear to have like cars and stuff are all videos, and he just established that, you know, videos are art. So I'm scrolling through here, y'all, and I don't see. Yeah, 12, he doesn't have a bunch of money and planes and nothing. It's you know, pictures of him, videos of rapping. There are some women, but it looks like they're in videos, some kind of promotional items. I don't know, the dude, I don't know, he looks pretty legit to me. Here's a picture of him with some beautiful women from 2019. I just followed him. If you want to follow me back, 12E. Okay. The prosecutor's behavior has been abhorrent. He's not as bad as Adrian Love, because Adrian Love burden shifted in the very beginning in her opening. I mean, she did like the biggest dumb thing that any prosecutor could ever do, talking dumb. But he's terrible. All right, so later on the 10th day, another thing that's really interesting, when the judge read the jury charges, he made that off of camera. And I don't really understand that. I don't understand why the whole trial can be on camera, but not the jury charges. I feel like the jury charges are a really important piece of like being an American and the law, and so to speak. So that I don't quite understand. All right, but later that same day, ASAP Louis came on. This man is balding yet has a ponytail. If you are a viewer and you are balding, cut the damn ponytail off, okay? Just go bald with beard. It's sexy as hell. All right, so now ASAP Lou is testifying about knowing that it was a prop gun. He also claims that the bullets they found in Rocky's house were actually his, etc.
I know he was jumped in a club in 2018. His face was cut.
Hold on. Sorry. He can testify to what he has observed related to that. If anything has been told to him, that would be in the school.
He was a stalker.
And can you tell us about the stalker?
The stalker has actually gotten into his home before. I saw the security footage, and I've actually encountered her in person before, and like just following me around.
Okay. And
That's scary.
There was an incident with the stalker.
It was Memorial Day of 21.
Around May of 2021?
That was it, yes.
Now, do you know of any security measures that Rocky took in response to these incidents?
Yes, he started getting security guard to sit outside his house 24 hours, and he started carrying a prop gun.
Yeah, I'm going to object. Last foundation.
How do you know that? What do you know about the security company and the prop gun?
I visibly saw them, both the prop gun and the security company.
Objection withdrawn. The objection withdrawn. All right, the objection withdrawn. Ask another question. Thank you. So what's your understanding of what a prop gun is?
It's a prop gun is something that looks like a real gun. It doesn't fire a projectile. It makes the same noise.
It does fire a projectile.
It's the prior violence. It just
One thing I learned from the Alec Baldwin case is that it is a real gun, and it does fire real projectiles, and it can actually end people's lives, okay? So a prop gun can be a really real gun, all right? Let's go.
Has he never used?
no.
Can you tell that from looking at the picture?
Personally, I guess, because I own firearms and I own other magazines. Usually, it has wear marks on the side of it from going in and out of the pistol of the firearm. So that one has nothing on it. It's clearly brand new. It's just loaded.
You don't have to take them all out. zoom in on it? Oh, wait. Okay. Why don't we do this? Yeah. So I want to get with this. When he was actually touring, you were making more money, is that correct?
Well, yeah, the more shows we do, the more I make it.
And in fact, when you were his assistant, that's when he paid you, correct?
I'm sorry, when I was an assistant, I got paid, yes.
And that was your primary source of income, correct?
In 2010, yeah, that was.
So historically, the defendant has been an extremely important source of income for you, is that right?
Yes, he's opened the door for me to have other opportunities aside from working directly from him to be able to further benefit financially. So I DJ on my own, like I said, not with him. I travel on my own. And recently, for the past couple of years, that's been the majority source of my income, yes.
And in terms of you being able to establish yourself as a DJ and your clothing brand, you have the defendant in large part to thank for that, don't you?
Sure, yes.
Now, I want to ask you, when did you first speak to the defense in this case?
In August of 2024.
So you're saying the very first time that you spoke to the defendant's lawyers was nearly 3 years after the incident?
That's correct.
Had you spoken to the defendant about this incident prior to that time?
Yeah.
Had you spoken to him numerous times about it?
More than once, sure, yeah.
So we're going to go back to the very beginning. When did you first hear about this incident on November 6th?
Okay, so the prosecution's trying to somehow establish bias because Lou made money with the guy. The fact that the defense didn't talk to him until August of 24 seems very regular. Like, I don't really hardcore dive into trial prep until the trial is coming. You know, there's other cases they're handling. Rocky's lawyer was defending Trump. So, you know, until I think August of 24, and that's when his calendar would have become free, and then that's when you would go talk to your witnesses. Like, that line of questioning as an attorney is kind of stupid to me. Like, I don't know if there are any lawyer jurors, but if there are, they're gonna tell the jury that that's dumb. Oh, here we go.
I want to tell you that when I make a mistake, I own it. I have no problem admitting when I made a mistake, and I made a mistake, and I'm going to tell you what the mistake was. Mr. Tappatina mentioned, and I missed this, the prosecution accepts their witness committing perjury. I missed that. There was an objection. I overruled it. I didn't hear the whole statement. I'm not accusing anybody of doing anything proper, but that statement puts the prosecutors in an unfair light, and that was improper. I overruled the objection. I should have sustained it. I don't want any side being disparaged or being put in a false light. So I made that mistake. I own it. I apologize. Go.
Thank you. Two things. One, by the way, I realized something. I said before that Mr. Efron said he'd seen the video previously when he said there were 2 shots. What I was talking about was when he was speaking to Wally. He had already seen the video. This was obviously after Rocky's arrest and after the civil suit was filed. So I wasn't suggesting he saw the video when he went to the police on November 8th, in case that came out unclear. My co-pastor thought it was. So anyway, now we're back on the Wally Jeffrey case. Look, all I'm saying is this. Their witness said those were fake. They played it as if they were real. So, whatever that means. But here, I'm going to go back to the crux of the Wally Jeffrey case, what we were allowed to play because they impeached the testimony of Efron. And what I argued to you, and what I'll say again, is the only crime that was proven here was relative extortion. He heard from his own mouth. And he boasted to Mrs. Jemmy that he was getting $30 million. He said, I already know I'm getting 30 M's. And I told you at the beginning of this case, I said in the opening, that there would be clear evidence of extortion, and here it is.
You know what I'm saying? You guys were back when I was lawyer first for extortion. You feel me? You're gonna have to deal with that in this political time.
everything else. Because once I walk away, when I get my cash, the case gets way weaker. It's just like a domestic violence case. If you was to hit your bitch and your bitch was to keep on going through with the situation, you go down. But if you're not there, then you're going against the state and it's way weaker.
Stop for a second, pause for a second. You know, what he's saying is obviously he's going to trade his cash for the case, sell the criminal case. So he'll get his cash and he'll disappear. The example he uses, the analogy he uses, is disgusting.
I'm glad he's pointed that out. I do not think the women jurors are going to appreciate that. His analogy is gross.
Of course, that's who, I don't know what front is, talking about a domestic violence case. He references hitting, he says you're a bitch, but that's how his mind thinks. That's his example that he could come up with. But it really just goes to show you who he is and how despicable he is. That was the example he gave. But what he's saying here is, get my cash, I'm gone. Get them. Play the next one, please.
If I'm not there, if he pays me out via through my lawsuit, I'll walk away. Basically, it's going to be called for the case and find me because I'm going to be on another island. Just relax. You get what I'm saying? They're going to be scrambling to find me because now they have to go against Rocky, the state. And here they have evidence in this and third, but it's not going to be the same when you present it to a jury and you don't have a complaining witness.
That's it. Game, set, and match.
Yep.
That's extortion. That's him trying to sell a criminal case for
Mm-hmm.
$30 million. That he will go to an island, be relaxing, if he gets his money. Too bad for them. They'll have to go look for him. They have to find him. Imagine poor Detective Flores having to go search around looking for Carol Efron as he's on an island sipping pina coladas somewhere for his $30 million. That's it. That's evidence of extortion. It's his mindset. He doesn't care about this. He just wants money.
They need to hurry though.
The only reason, and by the way, this transcript's a little tough to read, I think, because I can't see it, but you'll have to go back with you, and you'll have the transcripts. But again, remember, the only reason he's not on some island somewhere relaxing, and we're all here in the school, is because Rocky refused to be a victim of his extortion demands.
That's it.
And that's why he's using this trial, really.
Yep.
Using these prosecutors. Now he's trying to use you to get him his money. Because he knows that a conviction here will get him what he really wants in this civil case. That's it. This isn't about justice for him. It's about a payout and a payback. My last quote of some of the greats in our history, which I love using some of the words of our founding fathers, Thomas Jefferson, said an injured friend is the bitterest of foes. We saw that coming here, live and in color. Lest there be any questions about his true intentions, consider this. He sent an article, and you heard this testimony, to Wally Sajak on December 24th, 2024, just before this trial started, entitled, Rihanna Fears Heartbreaking Consequence of ASAP Rocky's Trial. And he sent it with a smiley face. A smiley face. This parasite is happy. If he can hurt that family, that woman, and her family, by sending a smiley face, like that's funny. That's funny. Because she fears the heartbreaking consequence of this trial. So he doesn't care about this trial. He just wants his money. He wants to be on an island relaxing. And he's laughing and mocking what he can do to Rihanna and them. And he needs you to get that done. Ladies and gentlemen, the prosecution has not proven this case not by a long shot. It's not even. This literally, I'm not telling you what to do. This can be a 5-minute verdict. You take as much time as you need. I'm not trying to impede on your province. The only thing proven beyond a reasonable doubt is that this relates to all that a pathological liar, a perjurer, and an extortionist. That's what's been proven beyond a reasonable doubt. And they know that. They know that. Because they asked Detective Flores the question that I just never heard. I used to be a prosecutor. It was a question that they asked.
That's improper argument.
Sustain
Withdraw.
that they know it's perjury. Sustain.
He used to be a prosecutor as well, Your Honor. It's not part of the evidence.
What was the saying, bro?
What?
I'm sorry, what was the saying, sir? What was the saying that what part?
That they know it was perjury.
I didn't say they knew. I didn't say they knew. I said what was proven beyond a reasonable doubt. That liar, perjurer, and source. Didn't say they knew. I understand the court's rulings.
You know, we objected regarding discussions in the prosecutor.
Okay.
Oh.
All right. So, anyway, what they know, they asked Detective Flores this question. Would you agree, Detective Flores, that you don't need Mr. Efron's truthful testimony to establish a shooting occurred? Well, first of all, if you do need it. You do. Remember, after breaking it down with Detective Flores, he made it clear to you they have nothing without him. We broke it down with him. We'll show you that transcript in a second. So you definitely need him, but it's just not credible. Why the heck do you think they asked that question? I mean, think about what that question screams out to you in the jury. We don't expect you to believe him, ladies and gentlemen. But it's okay. It's still proven. No, it's not okay. No, it's not okay. If you had to make a decision, the most important in your life or of that of your family is on his word, would you do it? Terrell Brown's word, would you do it? You all know the answer to that question is. What you're being asked to do is make that decision in the most important matter in his life. On his word. Please look at the evidence carefully. Please. Evaluate it cautiously. And you'll see that there's not proof beyond a reasonable doubt. Rakim is innocent. It's not only not that he's innocent. An innocent man's on trial with absolutely no concrete evidence against him. No reliable evidence against him at all. Because he's innocent. He's not the luckiest man for the face of the earth. Because there's absolutely no evidence of a shooting. And that heavy burden should not be yours to have to live with. On this evidence, it should not be. It's not right, it's not fair to ask you to do what the evidence won't to condemn an innocent man. And by the way, remember this, it's in your instructions. Circumstantial evidence. If the evidence points to both guilt and innocence, you must, there's no option here, you must side with innocence. If there's two interpretations of the evidence, guilt or innocence, you must side with innocence. That's what the law is, the judgment type. It's in your little books. Jury instructions. You must. It's not an option. Terrell Efron, I mean, what kind of system, seriously, folks, do we have if this kind of witness can convict someone and destroy their life? With all you know about him at this point. I've talked about there not being any forensic evidence in this case, no fingerprints, no DNA, there's none. No independent evidence outside of Terrell Efron. And ladies and gentlemen, the judge told you it only takes one lie under oath to throw this case out of court by you, if you choose. It's your decision. But just one. Just one lie. It's justification for you to say, I disregard all his testimony. You can't even count the number of lies he told under oath in this case. You can't. He lied directly, he lied to your face, he lied under oath over and over, he exaggerated, he turned around answers to try and avoid questions, he verbally assaulted me, he cursed in the courtroom, he threw a water bottle, flexed his muscles, he said he had enough, he was going to leave. How many does it take for you to know that this case is a fraud? To use Relly's own words, Relly's a fake. And he's just trying to profit off extorting Cashapp. He's just waiting for one thing, your verdict. Then he's got it. And if they come up and say, well, Relly's not on trial, that thought crosses your mind. It's true, he's not on trial, but he should be. He should be. Perjury, extortion. But he's not on trial. But what is on trial is his credibility. His credibility is on trial. And that you have to assess, and you get to assess. You must assess. The trial rises and falls on his word. With that in mind, again, I ask, what kind of system do we have if we pick on the word of that man? That man. With all you know about him. The issue in this case is the life, future, and liberty of Rakim. And that's what will be placed in your hands very shortly. And the question I have you before you first said, do you believe Tyrell Efron beyond a reasonable doubt? We're going to keep saying that because it's really what we need to discuss is beyond a reasonable doubt or not. If you don't, Rakim has to go free. And go home. He has to. Submit upon this testimony you've heard, the perjury you've witnessed, the lies you've seen, the destruction of pieces of evidence you've observed, the fabrication of others, Mr. Efron's trustworthiness. There's no way in the world that you can find that he's trustworthy beyond the reasonable doubt. There's no way. On the important issues in this case, so it's the ones he lied about. He lied about everything. He lied about the important issues. And if you can't do that, if anything they said to you, if anything they presented to you caused you to pause or wonder what really happened, if you have a doubt, a reasonable doubt, Rakim must be acquitted. He must be. That's our legal system. You just witnessed extortion demands throughout the trial of Efron, the lies, the hiding of evidence, the lie about being in Los Angeles 2 weeks before this incident with 9 million of the shell casings, on and on and on. And if you think he was lying about these important issues, the prosecution's case fails. Fails. So it's very simple, ladies and gentlemen. If you cannot believe Tyrell Efron beyond reasonable doubt, he must be acquitted. That's the law. A defendant in a criminal case is presumed innocent until the contrary is proved. In this case, it's not been proved. In the case of reasonable doubt, whether guilt is satisfactorily shown, until it is, he's entitled to verdict. And presumption placed upon the people that heavy burden of proving guilt is beyond reasonable doubt. And why is that standard called beyond reasonable doubt? Why? Look, there are many, I just want to give you some sort of analogies on this, but there are many legal systems around the world who don't have this proof beyond a reasonable doubt standard. They don't use juries, they use judges 1, 2, 3, sometimes 4. But our country has a philosophy, and that is we cannot convict people who are innocent. We cannot ruin their lives because what happens is so harmful, devastating, brutal, based on anything but the strongest evidence. And what is being attempted here? It's so harmful, so brutal, so potentially devastating to him. That's why there's such a high standard. Standard is higher than what you find in civil cases when you have disputes over money or property. If you have a reasonable doubt about this case, about the testimony, about the double talk, about the lies, the perjury, the manipulation of evidence, the destruction of evidence, Efron's motives, it's over. It's over. You must acquit Rakim. According to the law, it's that strict. Our system isn't perfect. You still have examples of people who are convicted and DNA later exonerates them because well-meaning juries didn't have evidence.
This is improper argument.
So you have those, you've heard of those, it's like 250 less. There's nothing to do with this case, right? But it's by jurors' who meant well, and then were subsequently exonerated by DNA evidence. Nonetheless, we have a system, and it's the best system in the world. It's the best system in the world here. It can't be perfect because human beings aren't perfect, but I'm begging you to honor that principle. Honor that principle of proof beyond reasonable doubt. Rakim must be acquitted under that standard with all the problems, the falsehoods, and the issues we've addressed. They cannot overcome them. They cannot overcome them. They can exaggerate. They can clean vote.
Okay, Taco.
They can mock terminology of our witnesses. They can be sarcastic, repeating their unimpeached testimony. They can do whatever they want. They can't prove this case beyond a reasonable doubt. This case never should have been brought to begin with, based on Tyrell Efron, once they learned who he was. These are what we call burdens of proof in our legal system. In a civil case, again, it's a dispute over money and property. The one side that proves preponderance of the evidence, that's standard. They get the verdict. Okay? And it's often described in very simple terms. If you have a scale, like scales of justice, if it just goes 51% to 49% in favor of one party, they win. That's a civil case. That's what preponderance of the evidence. That's enough to bankrupt somebody. That's enough to take away their business, leave them penniless. It is not enough to convict them of a crime. There's even a higher standard than that law called clear and convincing evidence. And clear and convincing evidence, for example, in custody disputes, for example, where the custody of a child is at stake. Clear and convincing evidence in some custody disputes, you can take a child away from the parent if you prove by clear and convincing evidence that that parent should not have custody. They have not met the standards for the legal system requires a parent. Clear and convincing evidence. Clear and convincing evidence alone is not enough to convict someone of a crime in the legal system. So take a child away, but not enough to convict of a crime. And let me ask you this. Do you think you've seen clear and convincing evidence in this case that Tyrell Efron is truthful, that he's believable, that he's honest, that he's honorable, does not have financial motive in this case, that is to be believed and trusted? They can't even meet the clear and convincing standard, let alone the highest standard in our legal system, which is beyond a reasonable doubt. To further explain
Move along.
beyond a reasonable doubt, the judge gave some great examples in the preliminary instructions and how high that standard is. If you think someone may be guilty, that's not enough. If you think perhaps they're guilty, that's not enough. If you suspect they might be guilty, that's not enough. Possibly guilty, it's not enough. Probably guilty, not enough. Guilty likely, not enough. Guilty highly likely, not enough. It has to be guilty beyond a reasonable doubt. Ladies and gentlemen, when you get into that jury room, ask yourself, do we have a reasonable doubt about Tyrell Efron in this case? Any. Because all it takes is one. Just one. Just one. You have 100. All it takes is one. Look, my time is almost up. I want to apologize to you again that this journey is taken. But you know, if you're seeking justice, there really are no shortcuts. If you betrayed trust with me, you want to fight hard and vigorously, especially if it was for a person who maintained their innocence from the get-go, from day one. And I hope and I trust that you understand that in a journey towards justice that there are no shortcuts. Let me tell you how this is going to proceed now. After I go after lunch, I think, or maybe now, the prosecution will get to go again for another submission, for a rebuttal submission.
Oh my God.
We have this one opportunity to address you because they have this very heavy burden, so they go first and next. They will seek to rebut, which I brought up. Presumably, they won't be back up here talking about all sorts of new things, or they'll face objection. But they have to seek to rebut what is being argued right now. And let me tell you up front, I'm loath to object during someone else's argument. I don't do it. I can do one before.
Correct. Completely
But
uncurious or uncourteous. courteous.
Maybe helping. Let me tell you also this. If he brings up anything new, we may be precluded from standing up again and saying, wait a minute, here's an answer to that. Wait a minute, ladies and gentlemen, you have an answer. But you can substitute your common sense. You all can substitute your common sense. Your judgment in that place, and that's required towards this journey. In this journey towards justice, you can substitute your common sense. You can respond for it. It's not out loud, don't do that. But you can respond. I'd like to remind you of something Judge Arnold told you. By the way, before I do that, I just want to also tell you that we're all very fortunate to have him as judge.
Amen. Amen.
I've been before many, many judges. His patience with us in particular, his humility, he is an inspiring role model for what a judge should be. So you're all very lucky.
Agreed.
I figure. Anyway, his Honor told you in the beginning that Mr. Lou will have the opportunity, the prosecution for this, Mr. Lou will have the opportunity to sum up last. It's not because I lost the coin toss. It's not because of that. At the beginning of this thing. It's because that's the rules. They have the very heavy burden, and those rules established by the state. So because they have the heavy burden of proving someone guilty beyond reasonable doubt, they go last, and that's a burden that never shifts to us. We have no burden. When a prosecutor has a particularly weak case like this, which stands or falls on evidence not worthy of belief, they always make some sort of pitch like, oh, the witnesses aren't on trial. I defy them to get up here and convince you that the evidence shows beyond a reasonable doubt that Rakim didn't act in self-defense or defense of another, or that the starter pistol was a real gun, beyond reasonable doubt. I defy them to explain to you why. Watch for attacks on the defense, watch for questions posed by him, knowing we're not allowed to respond. The law says you can respond for me. One other thing I'm going to pose to them right now. Remember yesterday I was telling you about this issue regarding cartridges from a prop gun. Because you heard about a prop gun can eject, does eject some sort of a casing. And I said to you, there's absolutely no evidence whatsoever regarding what blank casings from a prop gun look like. You heard evidence that from Lou Evans, the only one that was asked about it. There's paper and plastic in a prop gun bullet, so to speak. There's no evidence of how far or what direction they would be ejected to from the prop gun, whether they would still be intact or not, be split open. There's no evidence of that in this record at all. And certainly, this is no evidence that they would look anything like something that would be observable by the police, like those silver, shiny, metallic casings from a real firearm. No evidence whatsoever. I was told yesterday, there was an objection, I was told I was missing the evidence. I then said, first of all, I don't mistake the evidence, and I challenged the prosecution. Okay, if I'm mistaking the evidence today, when they get up, show the jury.
Your Honor, this is improper argument.
If I'm mistaken, show
The
jury.
objections.
If I'm mistaken the evidence, show them the evidence in this record that cartridges from a prop gun are metal or metallic or anything. Anything. There's no evidence in the record at all. I'm still going to state the evidence. They could probably should. Now, it comes a time for me now to conclude my remarks, and I may never have
thank
another
God.
opportunity to again. Certainly not this setting. Maybe when the case is over. And you've been told many, many times there are very hard burdens based upon the prosecution of people for good reasons. Prove this case beyond a reasonable doubt. And as such, it is Cadilac duty to answer for you as best it can any legitimate questions arising from the evidence which we believe is cast doubt on Rakim's guilt. There may be 1,000 such questions in a case like this, which we could put to them, but we intend no such exercise. We'll be here until the summer. I do think after careful deliberation that it might be fair to suggest 10 questions that literally hang in the air in this courtroom at this very moment. And as time approaches for you to decide this case, for us to hand it on to you as you will, I offer these questions now as the most important challenge to the prosecution. The prosecution claims it's met its burden in this case. They claim that. Well, if the burden has in fact been met, then you'll be given logical, sensible, credible, satisfying answers to each of these 10 questions. On the other hand, the questions are overwhelming or unanswerable. Those questions will be ignored, or you'll be told that the prosecution has no obligation to answer our questions. If you're giving anything less than complete, sensible, satisfactory responses to these 10 questions, beyond a reasonable doubt, you'll quickly realize that the case is transparent and false, and false. We prove real hard things for you, things you can see, things you can take back to the jury room. In light of this, you have to find Rakim not guilty. And when I'm concluded, and for Mr. Lewin's convenience, I should decide to deal with these very troublesome questions. I'm going to leave him the written list up here of questions when I conclude. Let's see if he wants to go through them or not, but I'm going to show you those 10 questions. Here they are. Let me go over them with you, one by one, very briefly. Question number 1. Other than Relly's word, what evidence is there that he photographed shell casings at the scene? Okay, there is none. We know that. Because even though they have photographs from his phone, they didn't get the metadata to show where those photos were taken. We also know they didn't get his GPS location at 11:45 that was shown where he was when he took those photos. Number 2, other than Relly's word, what evidence is there that the shell casings even came from the scene? No evidence other than his word. Lydia Parker's not here. Just talk about the metadata and the GPS location. Third question I asked him to answer. Other than Relly's word, what evidence is there that he even went back to the scene? Because now we know he swears that at 11:09, that's not him. That's not him anymore. And there is no video of him going back to the scene. So now we're left with his word again. Because they got Ill's GPS location, but not Relly's. Number 4. Other than Relly's word, what evidence is there that he ever left Los Angeles after going to a shooting range, shooting off 9mm, by the way, 2 weeks before the incident? Again, it's just his word that he left Los Angeles 2 weeks before. So he took a flight, and he took a flight back. That would have been a very easy one to prove. But we just have his word. Number 5. Other than Relly's word, what evidence is there that the scrapes on his knuckles were gunshot wounds?
That's a very good question.
He had to comment on that. Number 6. Other than Relly's word, what evidence is there that a conversation ever happened on November 5th to set the tone for November 6th between ASAP Bari and Rakim? Other than his word, there was no ASAP Bari, there's no phone records, so we just have to take Relly's word that happened. Number 7. In light of Lou Levin's testimony and in light of Lou Levin and 12B's unimpeached testimony, other than Relly's word, what evidence is there that Rakim did not carry problem? Other than Relly's word? There's none. No evidence of a shooting. Nothing from either video says that's not a problem. None. Number 8. Other than Relly's word, what evidence is there that he was shot by an operable semi-automatic firearm? Again, other than his word, no evidence whatsoever. Number 9, this one's my personal favorite. Number 9. how is it that you do not need Relly's truthful testimony, remember that question, to establish a shooting occurred when Detective Flores told you, A, the parking garage video does not show an operable gun. That's his testimony. So let me break it down this way. Video 1 alone, you don't know if the gun's operable, correct? Correct. B, the video from 1616 Pieces of Bar does not show if there's any gun at all. The answer to that was specifically just looking at that and not looking at anything else? No. Well, that's the video. Just looking at that? No. And C, the sound heard on the video from 6200 Hollywood Boulevard may have come from a replica firearm, according to Detective Flores. So, no evidence of an operable gun in one video. No evidence of the gun at all, or any shooting in the second video. And the pop, according to the case detective, could have come from a replica. So, do you need Relly's testimony? Because if you just don't have it, if you take it out, like was suggested in that question, Detective Flores told you there's no evidence. No evidence that there was a shooting or an operable firearm. And number 10, given that Relly told you he can lie whenever he wants, he's going to commit perjury multiple times. Relly told you he will commit perjury when he doesn't want to answer a question. How can you trust Relly with a matter of importance in your life, the life of a loved one, or the life you sit in judgment of? I don't know how they answer those questions. They can't. I believe these 10 questions right here. We'll see if you get answers. I don't think so. You have the capacity to transform this very dark 3.5 years into a bright tomorrow. You have that capacity. You have the power in your hands. It's up to you now. We're going to pass the baton to you now, or very soon anyway. And you will do the right thing, I'm sure of it. You made that commitment for justice. You'll do the right thing. I will go someday on other cases, no doubt. Mr. Lewin, Mr. Siegel, Mr. Brisloman, Mr. Kaplan. We will, Judge Arnold will try another case someday. I will. But this is Rocky's one day in court. By your decision, you control his very life in your hands. Treat it carefully. Treat it fairly. Be fair. Do the right thing. Remember the testimony of Terrell Efron and ask yourselves if you would trust him with any matter of importance in your life. And if the answer is no, you can't trust him with a matter of importance in his life. The case rises and falls just so with him. All you can do is try and give Rocky's life back. Imagine living under despicable accusation 3.5 years. Facing what he's facing, knowing he didn't do a thing wrong. It's been my privilege, my absolute privilege, and honor to represent someone that I admire as much as this man. And I thank his amazing family for putting their trust in me.
Them braids are on fire, man. They look so good. I feel like he redid them.
You ask questions in jury selection that if you had a doubt, would you have any problem saying not guilty? Would you have the courage to say not guilty? Did you have the mental fortitude to walk back into this courtroom if they failed to prove him guilty? You have the courage to walk back in here and say, we find him not guilty. You all said you could do that. You all said it. That's why you were picked. That's why the citizen of New York here. You knew that was part of your job. You said you could do it. I'm going to hold you to that, and I hope you hold yourselves to it. That's what makes the system great. Your courage. Your willingness to stand up for what's right. Look, this courtroom says Mark S. Arnold, Judge. He's the judge. Judge Arnold's courtroom. But when it comes to the facts in this case, it's your court. When it comes to what's right in this case, it's your court. when it comes to what's fair in this case, it's your courtroom. No one will take that from you. This is your courtroom right now. I'm going to tell you something.
Oh my God.
Here isn't right. Think about that. Because if the message would go and be sent out, that proof like this is not big. One of us, one of our citizens, none of us have a chance. Ladies and gentlemen, thank you for your patience. Thank you, Mark.
Finally, Jesus.
Take a break now, folks. Please be outside before we go to 1 o'clock. At which time?
Okay. Oof. My God. I thought the jury was actually going to get to deliberate today, but I highly doubt it. I know that the prosecution is going to take forever in their reclose, and I've been here for 4 hours. I'm exhausted and I'm hungry. I thought we were going to get to watch a deliberation. We were going to like count down to hear the verdict. And now I'm like, will we even get a verdict on Tuesday? At this rate, I swear. I swear. Okay, so I'm going to Austin to see my son this weekend. If on the trip there's somehow jury response or whatever, I'll go live from my phone. Otherwise, I guess I'll see you guys Tuesday. This is so fucking long. My closings are so brief. Here's the element, here's this, here's that, here's that. Thank you. I swear to Christ. I don't know, Patty. I don't think the jurors are going to deliberate today. On another and side and separate note, while we were watching this incredibly long closing, Tylen, our guest who was here earlier, brought me some very sad news. He has lost his cousin, and she passed this week. So Ghana sent me $5 on Cashapp today, which I greatly appreciate. If anyone else contributes on Cashapp, that is going to go directly to helping support his cousin's unfortunate funeral. It's a 20-year-old girl. So, he left for the day. He left to go be with his family. But if you choose to donate today, I'm going to apply that all to sending, helping with funeral arrangements, helping in any way I can. So hopefully we'll see Tylen on the show again, and hopefully things will work out for him. But unfortunately, I received that tragic news while I was streaming. So thank you guys so much for joining me today. I promise you, if there is a verdict, I'll come back on. Otherwise, I guess I'll see you Tuesday, and we'll go from there. Thank you.
From Mr. Miller. So please remember, keep an open mind. You have not heard everything. Don't discuss the case amongst yourselves or anybody else, and we'll see you in about 7 minutes.